Item 1 for motion.
No, one item 23.
Withdraw your lordship. Item 25, your lordship. As in Paxas. Admission item.
Item 1, what is it? Michael. Michael. Apna item 2 matile koi thako.
All mentions allowed. If anything else, let the item be called. Is item 1 who is appearing? GA Assam HL score. None appears for the petitioner. It is noticed that the writ petition was filed on 17/7/2023. No notice has been issued as yet. On 19/10/2023, adjournment was granted on the prayer of the petitioner. None appears today. List again. Next week, in the event of subsequent non-appearance, appropriate order shall follow.
Item 2.
Item 2, yes.
May I please, your lordship. DLC rejected compassionate.
Page number?
Lordship. Lordship, kindly peruse the additional affidavit, lordship.
Page
I
number.
have filed.
Page
Lordship,
number.
Page 1141 type copy, lordship.
Page number 40.
1 type copy.
1.
Serial number 8. These are all found.
When the man died,
Man died, lordship, 26/11/2001.
26/11/2000,
2001.
2001.
Yes. And date of application is 2/6/2004, lordship.
Why was it placed in 2015? Man died in 2001. 2004, he makes an application. Why did you consider it after 11 years, 2015? It should have been considered in the year 2004 itself, or at the best 2005. And after 11 years, you take a ground that there is a delay on his part. What about the delay on the part of the authorities? Don't know what to do. Yes, Mr. Kaushik, what to do with these matters? And if the man is died in 2001, it's almost now 24 years now,
Yes.
after a few days.
Okay.
Why should compassionate appointment now be considered? Means I find lashes everywhere. On your part, their part. Then again, from 2015, you did wait for another 8 years to come to the court. Do whatever you should notice, like Mr. Adams. You should notice returnable 6 weeks, extra copies, 3 days. Although the reason for rejection of late submission may be technically very right, but it's no longer a res integra that the requirement to file within 1 year is a directory requirement, not a mandatory. From such point of view, the rejection by the DLC of the application of the petitioner for late submission of application may not be tenable. But the respondents have to explain that if the application was made in the year 2004, why the DLC considered it in the year 2015, that is after 11 years. And the petitioner to explain that after 2015, why the writ petition is filed in the year 2023, that is after 8 years.
Lordship, earlier I have approved this honorable.
No, after 2015.
Yes.
You explained 8 years, you explained 11 years.
Item
Let's next week.
Pending of the writ petition shall not be
Next week,
further.
notice. Madam.
Notice to be listed next week.
Item 3.
Both the respondents as well as the petitioner to file respective affidavits explaining their stand on the delay indicated above. People put it there. Oh, নহলে এইটো এনেই থাকি যাব।
May I please, Lord?
Mm,
Yes, SLC rejected,
Page
Lordship.
number,
Page 40, Lordship. SLC
page 40.
40, Lordship. 40, Kasar district,
Noor Islam.
Noor Islam, Lordship.
Noor Islam, where is Noor Islam? Kachar, Noor
Kasar
Islam.
district, Serial
yeah.
number 1.
1 year and non-availability of norms means? Mr. Pegu, what do you understand by non-availability of norms? Don't know. Who appears for the government then? You appear, sorry,
D dash Burman is on her way, my lord. Can you be passed over for the
Who?
time? D dash Burman.
D,
D dash Burman. D Burman.
D Borgohai, okay. After some time.
Item 4,
The pharmacy council, yes,
Yes.
Mr. Gogoi.
My lord, but here I what I instructed. Because of a petition, that is, my lord, 2196 of 2023, 96 of 2023, the elections have not been held. There the issue was, my lord, this time, my lord, there was a proposal that, my lord, they will go for online, my lord, ballot. Voting, online voting, whereas the rule.
No, what we intend to do,
I pray Lordship may take up both these petitions on Tuesday. If it can be sorted out, then an entire committee can be constituted.
no, what I am feeling, merely because
Yes.
the act requires the registered pharmacists to also form a part of the council.
Yes.
And they have to elect 6 persons from amongst them.
Yes.
Because of their infighting, this election of 6 persons is not taking place. Does it mean they will hold it on a ransom that a council will not exist forever?
Okay.
Until and unless we arrive at our,
My lord, I
we
understand.
sort out our difference, hold the election, there will be no council in Assam. Can it be conceived in that way? This is what we are trying to ask you.
And, well, if that is taken up on Tuesday in the entire.
List along with WC so and so on
Yes,
Tuesday.
on Tuesday, Lordship will just get me done.
So if they want to hold their election, let them hold.
Yes.
And once they hold their election, whosoever is elected,
Yes.
they will be included later on.
Yes.
But in the meantime, with the other 9 members, constitute the council and let the council function.
Lordship. It is WBC 2196.
I think it will be inequitable to allow some private,
Renewals have not been made.
uh,
The new
lot of
pharmacies, they have not
council
been
is a
Yes, yes,
statutory body whose existence is required.
required to regulate the, my lord.
Hmm. And some few private individuals cannot scuttle the whole thing
Sure.
because it's a infighting amongst themselves.
2196
Tuesday.
2196, 2023.
List along with so and so Tuesday. যদি নহয় গৈ আকৌ Thursday fix কৰি লম।
item 5,
DLC which page?
Yes, Lordship.
You will kindly pass over for the time.
6,
Lordship. In this state petition, Lordship, earlier mother applied for compassionate appointment.
item 6, 5, 6, 7,
Wait, please, Lordship. Wait, please, Lordship.
Yes, what information you got?
My lord,
Because
yes,
a casual or a contractual teacher has no legal right that he will be regularized.
there is no proposition of law.
We can allow you to participate in the regular selection
That may be
process,
done.
and while doing so, some weightage, some consideration will be given to your past experience. Will you be happy with that?
Yes, ma'am.
Yes, Mr.
In
Give him
accordance
some
with
weightage
my
for his experience as casual and contractual.
Consideration only for my lord, otherwise my lord, many employees may be there, my lord,
No,
contractual
no.
employees.
Give them some weightage.
My lord.
They are experienced people.
But as per the rule, my lord, and what is the selection process, my lord? for
Where
the-
is the rules? Let us see. Why the rules they are so harsh that the man who worked for 10, 15 years will be simply be thrown out?
The lordship asked for consideration for that also, my lord. But in-
Something must be there in the rules also then. If it is not there, we'll try to give an interpretation. See, why does one man work in this
My
manner?
lord, my lord,
With the hope
in the Sabha Shiksha missions, he
that
is working,
in future he'll get a regular appointment.
my lord.
So when the occasion comes, if you don't take note of the long period of service he had already rendered, will he not be disadvantaged?
My lord.
Number
Yes, my
one.
lord, my lord.
Number two, if a man works for 10 years, he'll be around 35-year-old. Mr. Chutia,
My lord,
and you will require him to compete with a 25-year-old who is a fresh graduate.
my lord. Well, that
Will
is
the
correct,
fresh
my lord.
graduate not have an inherent advantage over him?
My lord,
How do you compensate this?
my lord, my lord. Regarding
This
my lord,
balance.
there's a not-
If you give him some weightage for his this
My
thing,
lord, my lord.
that balance will
Balance will
come.
be there, my lord. And for relaxation, there is a notification. of
Something
there, my
has to
lord.
be there. Which rule you are referring that there is nothing for consideration?
My lord,
Then
that is-
we'll state the rules for the time being then. And put it up
Assam-
before the division
my lord,
bench.
Secondary education provincialization service rule 2018 is there, and government school service rule.
No, this regular recruitment will be
Madam.
conducted under which rule?
My lord, secondary education provincialization school service rule 2018, if the school is a provincial school, my
I
lord.
don't know, it's a provincial school or what school? Provincial school. Which page is that rule?
18,
No. Page number of that book?
is number of that book, my lord, 18.
18.
18.
Rule is also 18, page also 18.
Page is all this. Is 29. He is a graduate teacher.
You are trying for a graduate teacher.
Rule 5. Sub-rule 5. Sub-rule
Where
5.
is that schedule 2?
Schedule 1.
Schedule 2.
Schedule 2 is
Mm,
is 49.
49 is criteria of a graduate teacher. 50, that one.
My lord.
You'll give or 60 marks for 15 years of experience as an undergraduate junior teacher in a provincialized higher secondary school, having requisite academic and professional qualification. Any experienced teacher who has appeared but could not secure shall be awarded at least 60 marks.
My lord.
Give the 60 marks, you'll get the 60 marks.
My lord. As per the rule, my lord. What about the- my lord.
Heard Mr. S. Paite, then counsel for petitioner, Mr. G. Chutia for the KAC, Mr. SMT Chisti for the Secondary Education Department, Government of Assam. The petitioner was appointed as, where is the appointment letter?
Paragraph 5.
No,
Paragraph
appointment letter, Mr. Paite, page number.
Page 30, my lord. Next set C.
Was appointed,
He was initially appointed in the year, my lord, 2001.
where is that?
My lord, that appointment order, I have not annexed, my lord, but
It is stated that the petitioner was initially appointed in the year 2001
as as assistant teacher
on casual basis or what?
under a regular sanction post.
Post may
On
be
casual
sanctioned.
basis.
What is
Yeah,
your
on
appointment?
casual basis.
As assistant teacher on a casual basis in the same school.
Initial appointment was, my lord, at Adarsa Rashtrabhasa High School.
At Adarsa Rashtrabhasa High School,
Adarsa Rashtrabhasa PVN within bracket PVN High School.
please tell the name in a more clear terms so that he can write Adarsa what?
Adarsa Rashtrabhasa within bracket PVN High School.
High School
Yes, my lord. Now,
against a leave vacancy. Thereafter, he was engaged thereafter, pursuant to the provisions of the Right to Education Act 2009 and having participated in a selection process as per advertisement number in number 2 page 13 diya ase dated so and so, the authorities under the Karbi Anglong Autonomous Council had engaged the petitioner Ram Janak Chauhan bearing TET roll number 3311025 as an assistant teacher and was posted at Longkiding EGS School under Socheng Block in the Karbi Anglong district. In this writ petition, the petitioner stakes a claim for a regular appointment against a vacancy that had arisen on the death of an existing teacher of the school, namely
Ramnath Thakur.
Ramnath Thakur. When the matter was heard on 22/1/2023, we required the Learned Council for the petitioner to provide any relevant provision of law which may provide for regularization of a teacher who was appointed on a casual contractual basis against any vacancy that may subsequently fall vacant, either due to death or retirement of any of the existing teacher. No such proposition has been put forward by the Learned Council for the petitioner. On the other hand, by the said order, we also required the Learned Council for the petitioner to obtain the information from the petitioner as to whether he would be satisfied with the direction that in the event a regular selection process is initiated against the aforesaid vacant post, he would be satisfied with a requirement to participate in such selection process, but with the required weightage, etc., for his earlier experience. Today, when the matter is taken up, Mr. S. Upaitai, Learned Council petitioner, states that the petitioner would be satisfied with such direction. Mr. G. Chutia, Learned Council for the respondents in the KAC, on the other hand, states that the selection for the vacant post referred above would be conducted by the authorities in the KAC as per the provisions of the Assam Secondary Education (Provincialized Schools) Rules 2018. Full stop. Accordingly, Mr. Chutia refers to section, no, rule. Which rule was for teacher?
Rule 8,
Eight.
29.
Page 29. Accordingly, it is submitted by Mr. G. Chotia that the recruitment would be done as per the provisions of Rule 8 of the Rules of 2018, which lays down the procedure for recruitment to the post of graduate teacher in a provincialized school. Inasmuch as it is an admitted position that the Lankiding EGS school is a provincialized school. A reading of Rule 8 makes it discernible that upon the applications being invited pursuant to an advertisement, the member secretary shall prepare a list of eligible candidates as per the provisions of Schedule 2 to the rules of 2018. We have perused the provisions of Schedule 2 to the rules of 2018, and from the provisions thereof, it is discernible that in the event a teacher was earlier working in some other capacity, comma, the clause 2 bracket 4, Roman 4 of the of Schedule 2 to the rules of 2018 requires that that a minimum of a 60% marks is to be allotted towards experience of 15 years of service as an undergraduate stroke junior teacher in a provincialized higher secondary school.
Who does not have the TET qualification.
Please don't interrupt. We'll add to it later on. কি বলো? 15 years of service as an undergraduate stroke junior teacher in a provincialized higher secondary school having requisite academic and professional qualification. And any experienced teacher who had appeared but could not secure the minimum qualification or qualifying 60 marks in TET shall also be awarded at least 60 marks if he or she had already completed 15 years of teaching experience. Accordingly, the petitioner is required to submit his application in respect of any advertisement that the authorities may call for pursuant to the aforesaid vacant post. And in the event the petitioner makes an application, the authorities shall take note of the provisions of clause 2 of the schedule, clause 2, 4 of the clause 2, 4 of the schedule to the rules of 2018 and examine as to what weightage the petitioner would be entitled for his earlier experience from the year 2001 and accordingly consider his application.
We'll look into Rule 6.
We asked you to look into it. We will not look into it.
Not specific is there, my lord, 25 marks for each year, my lord. 6 and 7.
Okay,
50
then
marks.
the heredity দিব.
6
And also provisions of rule 2,
6,
wha-
1 6 and 1 7.
no, provisions of the clause 2, 6 and 2, 7.
Well.
Look in other words,
Well.
whatever is entitled, give it to him. You use your discretion. We are not
Well,
asking you to do
well,
anything
60
specific.
or my lord 50, that is the my lord.
Whichever.
My lord.
So you use your discretion, you give him.
Well.
After all, he worked for how many years now?
My lord. There is Karmal provision is there, my lord.
Hmm.
50 marks is there. Or if it is fixed pay or otherwise it is my lord, Rule 7 is there. There is
So we-
special provisions are there.
You worked for 22
Well,
years after all.
well,
I'm deeply obliged.
Thank you.
Item 8.
In this case, my lord, the petitioner had approached the Guwahati University, my lord, He had,
To admit this
He had
petition, directly has to monitor the re-eval, respondent number one, monitor
it should be
re-evaluation and
responded, it should be Guwahati University, not the state. He had-
Who is respondent number one?
That is
One
state, but
should-
it should be respondent to my lordship, which should have been the Guwahati University should monitor. It should be the Guwahati. If there is some anomaly, lordship, Guwahati University should be. He had failed the sixth semester examination, then he had given it for re-evaluation, in the re-evaluation.
No. Can we issue a direction directing the vice chancellor to monitor any re-evaluation? Vice chancellor does not have that power. You check up the Guwahati University Act.
The Guwahati University.
Guwahati University Act, other day we dealt with that act. Mr. PJ Fukan had produced.
Yeah.
And I have the benefit of reading the powers of the vice chancellor for some another matter. I think vice chancellor does not have this power to monitor how answer script will be evaluated. Then from tomorrow, what will happen? Forget about re-evaluation. Somebody will say, I have doubt whether my answers will be properly evaluated. Let the vice chancellor give a personal supervision on my evaluation. What order will the court pass?
The
then?
respondent fee is there, the controller of examination is there.
And secondly, it's a presumption of a future legal right that may be violated. How a writ will be maintainable, Mr. Count?
Issue, my lord, is that when the
No, issue is there, I understand. No one comes to the court without an issue. But can we pass an order under 226?
only on the basis, my lord, that when they examine it, they
Look at the 226 provision is for a past violation of a legal right, not a prospective violation of a future legal right. It is not maintainable, Mr. Khan. Please examine it. I understand the apprehension. Suppose after re-evaluation, they don't do it properly. Come back to the court, point out that this was not done. We'll definitely call for every
then
record
in that
and
case,
look
let
into
them
it.
decide in a time frame manner, then let them. Because we had submitted this application, my
But
lord.
that will need Mr. Fukan. Where is Mr. PJ Fukan? What university?
On 5th of October, we have submitted, my lord.
No, that is okay. Re-evaluation.
2 months have already gone by.
That's okay. But if you read carefully 226, prospect of a future violation, that remedy is not available. If that happens tomorrow, it will be like 438 bail, pre-arrest bail applications. Everybody will come that I have a presumption that my right may be violated. Please protect it in advance.
I will ask him to, but this.
Take about that. That order you can pass, giving a time frame. We have to wait for some time till he comes.
Item 9.
Petitioner has been
Yes,
denied
Mr. For,
promotion.
sorry,
for- The petitioner has been denied promotion for availing maternity and childcare leave. This was.
where is that order?
There is. no
Promotion
order.
denied for taking maternity leave?
There is no order. The departmental promotion committee during the meeting orally informed her that you don't make the API score because you avail this leave. And my husband and I have been fighting before the director, the authorities of the college and under the Right to Information Act. Until date, no information has been.
Statement is made by Mr. P. Bhardwaj, and counsel petitioner, that the writ petitioner, Dr. Pallavi Soikia, had been denied promotion from which post?
My lord, this is under the career advancement.
No,
scheme,
no.
for-
Benefit under the Career Advancement Scheme, bracket CAS,
From-
for lecturers stroke librarians on being orally informed by the selection committee that she had availed maternity leave, therefore she does not meet the API score, and as such promotion would be denied. The records of the selection committee, which had considered the promotion claim by the petitioner be produced before the court on the next returnable date. Who will produce it?
My lord, this will be the college because,
Ah.
but they forward it to the director of higher.
The Director of Higher Education shall ensure the availability of records if necessary by calling it from the respective college authority. List next week.
Item 10,
I think you cannot do. See, even a person in maternity leave, support for 6 months, a person is in maternity leave, for 6 months, the person worked. The ACR has to be evaluated on the performance of those 6 months. By accepting it to be the performance for the whole year. Suppose in 1 year, you are required to say like our case, dispose of 20 cases. Okay. If a lady does it, dispose of 10 cases in 6 months, and next 6 months, she's deemed to have performed to the maximum ability. You can't say that for that year, he had done only 10, not 20. Please come back. This is a very little serious allegation if he had done so.
May I please?
Vote for.
Here the petitioner hearing your lordship. Your lordship. Differently able persons, your lordship. Pursuant to address, certificate has been issued in their favor, your lordship. And pursuant to
I said order dated 35. Notice regarding medical re-verification, 35. Yes, sir, where is the 35 order? But she was issued certificate, but later on rejected,
no, not rejected, your lordship.
asking you to go for re-verification.
So by the medical board
yeah.
constituted, and thereafter what happened, we don't know.
No, where is that order? Let us look into it.
Your lordship will
35.
kindly come to page 42. By this order, your lordship, our selection was kept on hold. Hold,
Page number 42.
page 42.
Pursuant to the appointment orders of the following and recommend.
Thereafter, a notice was issued, your lordship. That is a
Then just a minute. This is selection for grade 4.
lordship, grade 3 and 4. Grade 4, 3 and 4, your lordship. We are grade 4.
Yes, Mr. Kaushik, why this order was issued? Why was this order issued?
Well, this order was issued in terms of the direction of the personnel department.
No, why the personnel department issue? Where is the direction of the personnel department?
Well, lordship will find page 42 first line itself. In
No,
pursuant
you
to the government
noticed it.
personnel department.
No, can I have a look at the personnel department?
That I will have to, well, personnel department is represented by the government.
Is there any provision? Suppose somebody comes with a disability certificate, I'll not accept that certificate. I'll go for re-verification.
Well, what has happened earlier also, under an advertisement of the elementary education.
Mr. Kaushik,
Hello.
you cannot discard the disability certificate if it is issued by the competent authority. You have to accept it. But later on, you can make your own discrete inquiry, whether it is actually or not. And if it is actually, it is not a genuine or manipulated certificate, you'll have to issue notice to that person that we are not accepting your certificate, we'll dismiss you.
Hello.
We can't give you this appointment, continue with this appointment. You can do that.
Well,
But why I'm telling you, at the threshold, if you say I'm disbelieving every certificate, now go for re-verification. What? Just to rule out the possibility of fraudulent claims, you are also denying the genuine people. All 40 may not be fraudulent.
may not be.
Out of that, maybe few will be
Few
fraudulent.
would be.
But because of few, why will the personnel department say, you are not entertaining any certificate issued this thing, we'll make our own verification. Where is that provision under the disability law? It's not there.
And
This is like any other, say, caste certificate. Do we do that? Suppose a scheduled caste man comes with a certificate, I'm entitled to appointment under this quota. Do you refuse him? Saying that you go for a re-verification of your caste certificate and then come back? Why don't you do it?
Well, possibly this has happened.
There are many fraudulent cases of caste certificate. There are fraudulent cases of tribe certificate, fraudulent cases of OBC certificate.
Well,
Why don't you discard everything then?
possibly this has happened because in 2021, one advertisement of the elementary education.
Mr. Kaushik, once bitten, twice shy is not available under the law.
No, it is true. My lord, please correct me.
I know you were bitten once. Remedy will not
There,
be.
there were complaints regarding the false eligibility, disability certificate.
Who had made this complaint against whom?
There were certain complaints, my lord.
You have, if the person has come with a proper certificate issued by the competent authority, you will entertain it. Parallelly, you will also entertain the complaint, make your own verification, find out if you have materials that this is fraudulently obtained.
That is why, my lord, these appointments were kept on hold.
You cannot.
My lord, yes, my lord.
This is what we are
Just-
against you.
Just allow me, my lord, because what has happened, my lord, there were several certificates which were issued by the, under the act, my lord. A medical board was constituted by the GMCH, my lord, with the experts, my lord. And it was found, my lord, the person who had been, who was holding the disability certificate of having 50%, 60% disability, they were found of having disability of 5%. Some did not have the disability.
Mr. Kaushik, we very well understand.
My lord.
This is a case of a fraudulent claim.
My lord.
The possibility of fraudulent claim, in the past there were fraudulent claims. Both the reasons are not good enough to not to entertain any further certificates without your own verification. If it is a fraudulent claim, the man will enter the service. The day the fraud is detected by you, he will be out of the service. Because fraud vitiates everything and
True.
action can be taken at any stage.
My lord.
Even Supreme Court says, even after confirmation by the Supreme Court also you can take action if it is a fraud.
Right.
But likelihood of fraud may not be good sufficient administrative reason that we are going to block everything now for the time being.
Your lordship will allow the department, personnel department to produce this report.
Yes,
my lord.
madam.
An empowerment department is the necessary party, Lord, right? Because they have.
They are not necessary party. If they want, they will come before us. No, according to the personnel department, they are necessary. According to writ petition, they are not necessary.
Oh, Lord, they have page 45, Lord, kindly go.
Sorry.
Next time, second page 45. Lord. The notice was issued by the Associate Justice and Empowerment Department.
Maybe, definitely
Then
they are
Lordship,
not necessary party.
They have filed the appeal, Lordship, before the Associate Justice and Empowerment.
No, we have not. We have not filed.
Sorry,
Because your-
Madam Burman,
Yes.
we are not allowing these technical objections from here and there. Come to the core issue. Because the disabled people, they have a constitutional right and they also have a statutory legal right. And the statutes provide for a particular procedure. If they satisfy the procedure, you cannot put them on hold. Okay. But if there is a possibility that there is a fraud committed by them, that is totally different. But a possibility of fraud cannot be a reason to put it on hold.
Certificate issued by the Associate Welfare Department.
They reject that certificate. Madam Burman, please come to terms. If the certificate is not appropriately issued by the authority, don't accept that certificate. And you reject that candidature. But you cannot put on hold en masse and saying that we are going to now make our own inquiry and only then we'll appoint you. You are degrading these disabled people by doing that. There's society already looks them a little down and you are bringing them further down. So we'll not allow you to do that. Understand? Howsoever you may seek to justify, we will not allow you to do that.
But there, my lord, in that situation. we
Mr.
found-
Kaushik, third time repeating,
Well,
possibility of something happening can never be a reason.
No, that was not a possible.
So
but
today,
our attempt-
today, if the court holds a view, there is a possibility that the lawyers may mislead. So I'm not allowing any lawyer to come into the court.
that-
Can I do that?
No.
Mhm. Misleading also happens quite often. We detect it, we take action. Suppose I take note that lot of misleading statements are made by the lawyers. So we're putting on hold the entry of the lawyers to the court. Will it be acceptable? Till the High Court will make a individual verification, and only then we'll allow it to enter. The same principle is applicable.
No, they paste 42 the order impugned here in this petition.
We are going to set aside.
Yes, Malad, this is based on the report of the personnel department. We had done it only, Malad, the education.
Mr.
department.
Kaushik,
No.
for the citizens, it is one government of Assam.
Malad.
It is for your administrative convenience. I am education, other one is personal, other one is social justice. It is your internal arrangement to carry out your work.
Sure. As a council.
The left hand can never say, I am not responsible, the right hand had given the slap to somebody. Can they ever you say?
No, that,
It, person as a whole gives the
that's a one function.
same argument you were making.
No, but why I'm saying, Malad, because
Come back with records.
I'll
We have
come
heard
back
you.
to
now.
the report of the.
Come back on Monday. Yes, Monday. No, we can't allow these disabled people to be treated in this manner. Why? Monday personally you were not there. Usually on a Wednesday you go. List again on Wednesday. The respondents in the education department as well as the personnel department, and if necessary, any other department of the government of Assam. As a mention had been made that social justice and environment department is also in a severity to make available before the court the complete records justifying the order dated 35/2023, keeping on hold the appointment of the grade 4 persons under the disability law, as because the authorities intend to make some kind of an inquiry on the authenticity of the disability certificates, and that till such outcome is received, the appointment order shall be put on hold. A fundamental question would arise if all the appointments across the board are put on hold to enable the respondents to verify that the respondents are on a presumption that some of the claimants may have based their claims based either upon fraudulent documents or fraudulent certificates or unacceptable certificates. A mere presumption of there being a fraud or there being an illegality in the claim cannot be a reason to put on hold. Prima facie cannot be a reason to put on hold the entire recruitment. As because there is also an equal or more possibility that there will be many other genuine disabled candidates who would also be denied of their appointment because of such a move. Justify it. You got my example. Tomorrow I debar everybody. What will happen? That we have noticed that repeatedly misleading presentations are made. Let us debar and make an inquiry, and then only then we'll allow. But however, the respondents are allowed to conduct any inquiry that may make as to whether any of the individual certificates of the selected and to be appointed candidates are fraudulent or illegal in any manner. If it is so, it may be a case to take action against the individual persons rather than action en masse against all the selected candidates, merely because the authorities are of view that there is a possibility of any fraudulent certificate or illegal certificate and because their past experience shows that fraudulent and illegal certificates were relied upon in case of claim for appointment under the disability law. List Wednesday for further consideration. If necessary, respondents may file their affidavit before the next returnable date. We are passing some orders.
Item 11.
And in the meantime, if you can identify, tell us. Maybe if you produce materials, specifically few people will say that they give, sorry. Huh. If you have materials, tell us. Place it before the court that this ex-candidate is holding a fraudulent certificate. We'll take note of that in our order.
Therefore, my lord, the candidates, my lord, were asked to appear before the medical board, and when it was examined, in fact, your lordship, we will be surprised, my lord. There were 70% of the candidates who did not even appear for the medical board. I did not challenge also. 30% of the candidates, their certificates, their medical.
No, you cancel the certificate.
No, their medical disability were found to be not
Mr.
in terms of.
Mr. Kaushik, whosoever issued the certificate, ask them to re-verify it and tell you if somebody is fraudulent. If fraudulent, even if this man is appointed, issue notice, dismiss him. Because fraud will vitiate everything. That is the equity is in your favor from that point of view. But that doesn't mean across the board.
Yes.
Are you not degrading those genuine disabled people? Think it from the other point of view. You are thinking from only
No, no,
one
it's
point
true.
of view. They are already looked down by the society, and you are adding further injury to them. Yes,
By this application, my lord, I have challenged the impune release order, page 46, my lord,
page 46.
of the petition. By which the petitioner has been released from service, my lord. She was temporarily engaged in.
You have been
Pragyotis College.
released from your temporary service with
Yes.
Pragyotis College.
Initially, she was engaged in the year 2000.
What right you have to continue?
My lord, what had happened, my lord?
No, no, not
That's-
happened.
There is specifically, my lord, there is no right at all. my
And
lord.
then,
But the temporary servant also entitled for certain protection, my lord.
which,
Without
part-
any
under which
regular
law,
inquiry.
under which law?
My lord, as my lord, the apex court has said, my lord.
Apex court, which one? Mr. Islam, you produce us the law you are relying on. If that law is violated, we'll pass the order. Don't worry. But you have to substantiate this. Paragraph?
My lord, para 7, my lord. The probationary, like a temporary servant, is also entitled to certain protection. His service cannot be terminated arbitrarily, none can be those service be terminated in a punitive manner. In this case, what happened?
It's a punitive manner.
Yes, but
No, termination simpliciter and punitive termination are different under the law.
But my lord, as per the show cause notice, my lord, the show cause notice has been issued, the page 44, my lord, to her. In the show cause notice, the basic allegation level against her is that after the grade for employee regular post has been advertised during her continuation as a temporary employee.
This
She was-
is Sarmila Ras is a grade 4 employee.
Grade for him.
Huh.
She was applied for the regular employment, my lord, but she could not get the.
Hmm.
Therefore, she submitted an application before the director as well as before the chief minister of Assam, my lord, for her justice, my lord.
What
Only
justice?
because of filing of the,
No, you go to the director and the minister.
because of that,
They'll give you, because their jurisdiction is different from our jurisdiction.
yes,
The executive authority has some administrative jurisdiction that even if somebody is not entitled to something, it may be given. But a court of law cannot do it.
for that,
Court of law can give you only when you have a right.
well,
and
only
the right
for
is-
that reason, my lord, the focus notice has been issued to her.
Sorry,
Only for that manner, the.
that she
submission
had
of the-
approached the minister, so therefore a show cause notice has
Show
been
cause notice
given.
has
Where
been-
is the show cause notice?
Show cause notice is at page 44.
44.
44. But no regular inquiry has been conducted and suddenly this release order has been. Peaceful.
What is the irrelevant complaint? What did you say to the chief minister?
My lord, this is at page, my lord, 40, my lord, 40.
42, Nyay Bisari Abedan, that
Yes.
one.
Yes, my lord.
What kind of Nyay? These are vague allegations.
Yes, my lord.
আৰু তেওঁ দুখত লোকৰ কথা শুনি মোক একো প্ৰমাণ নোহোৱাকৈ মোক মানসিকভাৱে শাস্তি দিছে. See, person was working as junior assistant without qualification. The principal is very kind with her, saying that we can never appoint
Yes.
because you don't have the qualification. Please work as a grade 4.
Yes.
So she is working as a grade 4.
Yes.
And what is the Manohik Kosto dise?
That's
If
right,
you
my lord.
claim something you are not entitled and you are refused, will it be Manohik Kosto?
In fact, my lord, I could not.
Then tomorrow, suppose a court dismisses the petition, will you say the court is giving Manohik
Yes,
Kosto?
yes,
Why? You are not entitled,
But
you are dismissed.
I,
That means you are trying to blackmail the authorities, emotional blackmail, that if you don't, I am going to this thing.
my lord, I could
So you
not-
are basically a criminal minded
my lord, I
person.
could not interact with the petitioner because.
No,
by
this
way of-
is approach.
By way of legal,
Intention shows the criminal mind of the person.
yes, my lord, if we go through the entire.
So
something,
why do you put the chief minister in this kind of a situation?
And I could not interact with the petitioner because. my lord,
So
is
the
that-
college is right that today you are taking this, tomorrow you don't know what you will do with them.
At least, my lord, my humble submission, my lord, since the Shoko's notice has been issued, my lord, a regular inquiry can be made, my lord, by the authority.
What will you give a reply? Give a reply now only,
Reply
they are
has
asking
given,
some
my lord.
questions.
Reply has given, reply is
কিন্তু
at page
কোনো কাৰণ
45.
নহল আৰু বিগত 4 বছৰ মোৰ কোনো দৰমহা পোৱা নাই.
And she maintaining her livelihood only upon this grade for.
No, is he working as grade 4? Mr. Is he working as a grade 4 or not
See,
working?
As per page 35, Lordship.
No,
this
page 42, that representation.
Representation was after that, sir, Lordship, regular interview process was held, Lordship.
No. She was demoted to grade 4. That is
No,
okay.
Lordship, that part is as part of Lordship.
আৰু
that-
তেওঁ অহাৰ এসপ্তাহৰ পৰাই বিনা দুখত মানসিকভাৱে কষ্ট দিছে. এই বিষয়ে মই কিছুমান শিক্ষকক পঢ়ুৱালো কিন্তু কোনো ব্যৱস্থা নহল আৰু বিগত 4 বছৰৰ মোৰ কোনো দৰমহা নাই.
Lordship, against this,
And
Lordship,
there's-
my lord may kindly peruse page 44, Lordship.
ইমানবোৰ পাছতো মই you show cause to all these colleges not to keep this kind of people. From 2006, why are you misleading one person that you are going to get something and work?
Yes, Lordship.
This is where we find some illegality. On the other day also, I think I took up one matter
Lordship.
that
Lordship, time and again, Lordship,
your honorary appointment after provincialization or this thing, not permissible in law.
Lordship.
So if it is not permissible law, you are not entitled to regularize them.
Lordship.
But does it mean you will exploit them?
That cannot.
From which constitutional provision you get the right
It's lordship violation
that
of,
just because somebody is not entitled to regularization, I'm going to extract that service without giving anything.
that's amount of course about 23 lordship.
23 is violated.
Lordship.
How can you do all this?
Otherwise, lordship, the authority of higher education department, lordship, time and again, lordship, reiterated as per lordship's view.
So
That-
definitely she may be right. Manohika hasti dise.
Lordship, time and
So a
again.
person, day in, day out, you compel the person to work, knowing this person will never get anything.
Lordship, already we have issued lordship various notification not to engage lordship such kind
Your
of.
notification is not sufficient. Implementation of the notification, have you done something?
Lordship, that.
Had you done this case, would not
that
have come before us.
notification, lordship, there is a penal provision also, lordship. That notification issued by the government, lordship, they have indicated.
Have you taken action against one college till now?
Lordship, that part, I cannot.
So
Even lordship, the allegation which is basically.
suppose the state enacts CRPC and IBC,
Lordship,
murder is committed, but don't do anything.
that part. Lordship. Even lordship, 42 lordships is that after going to.
We have some sympathy for them, may not be in the way
Lordship,
the right is claimed.
regarding a release.
No, you release also.
Release part lordship, it is not related with the Sokos notice. Sokos,
No, but now you release her after paying for all the services that have already been extracted.
Lordship,
If you pay that amount, this person can invest that in some small business here and there and have a livelihood.
my lord, make page 36. Lordship. Page 36 is the joining the report, lordship. And page 35 is the lordship appointment, lordship.
Very well.
Appointment is a temporary lordship, full-time junior assistant, lordship.
Mr. Gogoi, the whole difficulty is department looks it only from the point of view of the rules and regulations and whether I can regularly appoint you, Uma Devi, and all kind of laws you know. But does any of the law permit these government authorities to extract free service from a person?
No, that cannot be, lordship. That cannot be.
But it is done for the last almost
Lordship.
nearly 20 years now.
Lordship, that part, lordship, she is voluntarily is a temporary work.
No one voluntarily does it, don't tell me.
Lordship. Otherwise.
Aru, and one more thing, college always like, Bina Betone. You are the dominant party in this arrangement. State is a dominant party. There is a law that any line a dominant party adds has no relevance in law.
That part today, lordship.
Just because you write Bene Betone, does it mean the person is voluntarily doing it or the person is doing it with some hope somewhere?
From Ray, she is.
Because this is great for a person who would have gone for work of daily wage labor in somebody's house. Otherwise, she would have got some remuneration for that.
There, lordship.
Why she'll go to your college and
Lordship.
serve everybody?
I will indicate that part, lordship. I will communicate that part, the view of the lordship. Otherwise, lordship, regarding lordship.
The
Of course,
principal of Pragjyotish College to show cause on the next returnable date that if the petitioner Sharmila Das is not entitled to any regular appointment, any salary from the college authorities, either in grade 4 or in grade 3, why the services of the person was extracted by the college authorities from the year 2006, resulting in a situation of the impugned communication of 39/2023 being passed, that she is now released from service. The amount of compensation, such conduct of the college authority prima facie violates Article 23 of the Constitution, and their conduct can be construed to be a case of engaging persons on forced labor. The principal to appear before the court either personally or through a counsel, as may be advised, and the Director of Higher Education Assam to communicate with the principal for doing the needful. The state authorities shall also inform the court as to why these kind of arrangements are allowed to be pursued by the entities under the state, where the employer knowingly engages a person without any financial remuneration, and also knowing very well that the person will never be regularized under the rules. Whenever such matters are confronted, the only submission of state authorities is that under the rules, they are not entitled to regularization. We are not on the question whether they are entitled for regular under law. We are on the question as to why a person had been subjected to a forced labor by the state authorities, knowing that under the rules, the person is not entitled to a regularization. For the reply thereof, list Wednesday.
Now, Lordship, something will come, Lordship. Otherwise, Lordship, they have issued notification, but no action has taken.
Do it.
Now something is come, yes, because,
And for whatever you extracted, you give it back.
yes, because Lordship has indicated.
And you are not entitled to limitation also. That it's a money claim 3 years past.
Lordship,
It's a case of fraud,
Lordship,
and fraud has no limitation.
Lordship.
Give something.
My lord may give.
Give something to all these category of employees wherever you find out. Pay them something,
And Lordship, honorarily they have to go.
honorably say,
Lord.
take this money and go and do something
Lord.
else.
Lord. Lord.
But don't give these false hopes
Lordship.
all the time. I know the expression, "Thakasun thaka aru olop din kiba eta koribo paru niki sao." Don't, not this expression. Accordingly, the Secretary Government of Assam in Higher Education, the Director of Higher Education, and the Principal of Pragati's College to respond.
Lordship.
Maybe the Lordship, matter pertains to compassionate appointment, your Lordship.
DLC,
Yes, not considered yet.
not considered. Same order, not considered.
2001 Lordship.
Reject it, saying that. You have to place it and reject it.
Yes, sir.
The only objection raised by MSDD Burman learned additional is that the death had occurred in the year 2001. If it is so, the DLC may also take note of the said submission and pass orders accordingly. Luckily placed before the DLC, and if placed, informed.
13.
This is also compassionate appointment, Lordship. The further is right in 2001, Lordship.
Page number.
Lordship, the application is not available, Lordship. But from the page 19, Lordship.
No, what is this matter?
That's compassionate appointment, Lordship.
Compassionate, placed before DLC.
Lordship, it was placed only on 2022, Lordship.
No, let it be placed. It's placed.
Lordship.
Was it placed before DLC?
Yes, Lord.
What the DLC?
DLC rejected it on the ground that 2 years is already.
Page number.
Page number 27.
You got to choice. Huh?
Yes, Mr. Dury.
It has been rejected on two grounds.
No, we have read it.
Moreover, the
Hmm.
5% vacancy. So by the Ranjana I spent for
Spent force means,
Lordship.
where is the sports and where is the spent?
Lordship by Achyut Ranjan Das. Yes, comparative analysis from that.
No. Where is the force?
Since
For
the
the
matter is
force to have been spent, there must be some force. Where is the force?
uh, very concept that die in harness, your lordship, that was. So.
No. 2 years flows from one of your notifications,
Yes,
which
Yes.
says that once it is considered but could not be entertained because of unavailability of vacancy and 2 years have passed by, it will spend its force.
yes, your lordship.
From there, you get the expression spend force.
Yes.
But to invoke that, earlier it must be placed and rejected. Here it is rejected for the first time. So spend force is not available. Spend force has a condition precedent. Earlier it must be placed. That condition precedent is not here. Have some compassion also. They are compassionate appointments. These are not all civil cases where technicality of law will prevail. Heard Mr. B. Gogoi and also heard Mr. B. Deori going to advocate for the Chief Secretary for the Deputy Commissioner Nagaon, Mr. Ganesh Pegu for the Authorities Elementary Education Department, Government of Assam. The father of the petitioner, Samin Chandra Boduloi, was a grade 4 employee, who was a grade 4 employee of Bhokatgaon Monipurtup ME School in the Nagaon district, died in harness on 7/2/2001, and on his death, the petitioner submitted an application for compassionate appointment on when did you make the application?
The application is not available.
Ever made an application for compassionate appointment? It is also taken note that upon death of his father, the managing committee of Bhokatgaon Monipurtup ME School, by their resolution number 5 dated 28/12/2002, appointed the petitioner as a grade 4 employee and allowed him to work till 36/2010. But the said appointment was construed by the authorities to be an appointment on honorary basis in a provincial school, which may be impermissible in law. Thereafter, the authorities placed a proposal for appointment on compassionate ground, and accordingly, the matter was placed before the DLC of Nagaon district in its meeting of 14/2/2022. The DLC rejected it by providing that a period of 2 years since making of application is over, and therefore it has spent its force, and further there is no vacancy in the department against 5%, or vacancy of 5% available for compassionate appointment. Firstly, we are of the view that when the petitioner was appointed in the year 2002, it ought to have been a regular appointment for on compassionate ground, and ought not to have been an honorary appointment in violation of the rules, in as much as no honorary appointment can be made by the managing committee in a provincialized school. That is the first illegality in the approach of the respondents, which is noticed that had been meted to the petitioner. Secondly, after making the petitioner to work up to 2010, the authorities were of the view that now the petitioner should be considered for compassionate appointment. And accordingly, some prior application was placed before the DLC. In the DLC, which again considered the application in the year 2022, that is almost after lapse of 12 years. At the following the aforesaid procedure, ultimately DLC rejects on a technical ground that the application had spent force as 2 years had elapsed. And there is no 5% vacancy. After 20 years of a required due consideration by the authorities, it cannot be expected that vacancies would still exist. So therefore, the reasoning itself is an arbitrary reasoning by the DLC. Secondly, the principle of spending force after 2 years is on a premises that the application was earlier placed before the DLC but rejected for want of vacancy. In the instant case, no material is available that it was earlier placed and rejected. From such point of view, even the principle of spending force after 2 years is inapplicable. Considering the matter entirely remanded back to the DLC of Nagaon district for a fresh consideration as per law. If vacancies are not available in the department where the deceased at work, the education department to also explore as to whether vacancies are available in any other department. And after completing the inter exercise, pass a reasoned order. And to be placed before the next.
14.
The respondent should also take note that it is the conduct of some authorities under the respondents that the petitioner had to face the present fate, which had already been elaborately noted above. And while taking a decision, the said aspect be also kept in mind.
This is a compassionate appointment, Lord. The petitioner father of this died in the year of 2016, Lord.
Was it placed DLC?
Lordship. DLC.
Page number?
16, Lord.
16.
Lord. It is start from 16, Lord. And the legal person at page 18, Lord.
18.
18.
Name of this man?
Lordship.
Deep-
Second paragraph.
Dipamoni. Where is Dipamoni?
Second paragraph, Lordship. The district level committee could not recommend a proposal of Dipamoni Guhai for assistant reserve post due to want of vacancy. Lord.
Where you were reading?
It is from page
Page
18.
18, second line, Lordship.
It's a put you to want of vacancy.
Her name was repeated at serial number 27, Lordship. That is page 17.
But some of them were given.
Lord. They considered the case of the 2001, 2006, like this, Lord. Page 17 is the list of the candidates, Lord.
Page 17 is.
Lordship. And my name is at serial number 27, Lordship.
20.
27.
Mr. Deori,
Yes, Your Lordship.
is the DLC making a selection on merit? Or you are making a selection for compassionate appointment? Who is the financially worse off? Financial, that is not there at all. All you have done is find out who is good in merit, who got more marks in the metric exam. DLC cannot substitute itself and become a selection committee.
That is the last criteria, can be.
Sorry.
That is the last criteria. Financially, they are same. If they are.
You
they
can
are
say
same.
if somebody is not qualified, you may not appoint. But you cannot say that all the candidates, I'll make a assessment on merit, who is the best suitable, I'll give it to him. It is not a regular selection.
Indeed.
I think that is what has been done. What to do? That's why I told you the other day,
Yes, yes, Lordship. That's right.
whatever is required to be done, you are doing everything else other than that requirement. And this is requiring the court to interfere with in almost every recommendation. You are giving us the handle to do it. Look at page 17. I think it's a merit evaluation.
Yes.
Deepa Moni got 36.8% marks, so not recommended. Somebody got 54 marks, recommended.
No, your lordship, not exactly like that, number, 10, serial number 10
Hmm.
is 62.57, not eligible.
Which one?
At that particular list only, page 17.
Only one man.
That is the case of the total.
No, that is not eligible for some other reason.
It is a date after 31/3/2020
No,
calendar.
No, you have to cover recent no list.
Yes, Mr. Gogoi is right, because date of death, they are not covered for compassionate
Yes.
appointment. That is why not eligible. Otherwise, it's a merit. Compare the names. Compare the names in the first table and in the second table. It's apparent that you have gone for merit selection.
28/7.
Whosoever has got less marks is not selected.
No, but your lordship, the rejection of that particular Deepa Moni Gohai, the ground that has been stated is not that she is not qualified due to percentage or lack of percentage. It has been rejected on the ground of want of vacancy, your lordship.
But we have to look what you have done, not what you have stated. What you have stated is right. What you have not done is not right.
May give her the chance in any other department.
Do it. Otherwise, we are going to set aside everybody's appointment. In this case, if I issue notice and hear it actually on its merit, this will require setting aside all the appointments. And I don't want to do that. Somebody is appointed, why set aside? If you like to contest, you are free to contest.
That also says if someone is appointed, your lordship, cannot go into that.
The law also says whatever is required to be done should be done as per law and not in an arbitrary manner.
Lordship, that may be in considering other departments.
Otherwise, this will, order will be more harsh otherwise if you don't do it. Mr. B. Gogoi, Mr. B. Dovri for the. Deputy Commissioner Dhemaji, Mr. Ganesh Pegu for Elementary Education Department, the father of the petitioner, Kanak Gohai, who was a grade 4 employee in the Postim Cement Sapori ME School, Dhemaji, died in harness on 30/9/2016 and on his death made an application for compassion upon 26/12/2016, which was placed before the DLC of Dhemaji district in its meeting of 11/2/2022. The DLC took into consideration a total of 28 number of applications, and out of that 24 were recommended. And application of petitioners stood rejected by providing the reason of want of vacancy. But when the resolution of the DLC is examined, it is noticed that the examine, nothing is discernible that the requirement of law of making an inter-se financial comparison and to find out who is financially worse off was made. A reading of the resolution indicates that there may have been a merit evaluation by the DLC in respect of the candidates, which would be impermissible under the law of compassionate appointment. The DLC is not required to do a regular selection to make a merit evaluation and recommend the candidates for compassionate appointment. But however, on the submission of Mr. B. Dewry, the matter stands remanded back to the DLC for a fresh consideration to examine the claim of the petitioner against any other vacancy that may be available presently either in the education department or in any other department. Accordingly, the rejection by the DLC dated, so in respect of the rejection of petitioner is set aside.
Item 15,
Safety of lecture.
Otherwise, petitioner is given liberty to assail the DLC dated so and so, if so advised. Otherwise, we are going to set aside the whole thing. Yes, Mr. Boyce.
The petitioner is the first class master degree holder and he has completed select also. My lord,
You should notice to issue.
kindly come to
Not
page
this
44.
select.
That is annexure 12 is the advertisement for a post in physics department in Salwari College
Somebody is selected from outside BTC
outside the
and the petitioner is from within BTC.
exactly.
Where is that selection?
My lord,
Apprehending, not selected.
my lord, we filed
Yeah.
the RTI application. Till date, they have not furnished it. Kindly
They have not, they have not,
furnish the selection of that candidate.
selection already over.
My lord, yes, on the petition.
But the final, the selection is not there. He is apprehending that the person, he is from BTC. If the person from outside the BTC will be apprehending that.
So have you selected somebody from outside?
No, no.
No, final is not done. In the preliminary, is
No,
there
that-
any
that
candidate
instruction
from
I don't
outside
like.
available?
That instruction I don't know. He says he is the only.
Only one
person.
thing, we direct you to look into the aspect.
Not.
We are not passing any order. Let the director, BTC, education BTC, look into this aspect as to whether in the selection process, candidates from outside the BTC are also included. And
My lord, already in the physics department, the other two candidates were appointed.
no, we are not on individual cases because moving to individual, we have to issue notice.
My lord. Let him take instruction, please.
You want instruction.
Status.
Instead of instruction, you just look into this aspect and pass appropriate order. That's all.
My lord.
Heard Mr. G. Boyce, learned counsel for the petitioner, also heard Mr. S. Bora, learned counsel for the authority in BTC, and Mr. K. Gogoi for the Higher Education Department, Government of Assam. The petitioner participated in a selection process pursuant to an advertisement dated 12/3/2023.
I can indicate one.
Sorry.
If lordship permit, I can indicate one. With apology, lordship. The advertisement, lordship, seems to be violation of Article 16 only. Otherwise, within the state, lordship, we cannot lordship from the particular area, particular district, we can give preference.
No, no one is challenging this
Lordship.
for us. Where is the advertisement?
Lordship.
Page number?
Page 44. My lord, he cannot say that, my lord, it is their circular.
Just I am indicating.
And
as a
then
comment.
which clause, Mr. Gogoi?
Clause, terms and condition, clause number 2.
Even
Towards
lord-
right hand, my lord.
Even lordship, same issue as.
No, which clause Mr. Gogoi is referring?
Lordship.
Terms and conditions.
Lordship, two lordship.
As per BTC order dated 8th February.
Lordship, that was also put to silence in another expedition, which is fixed by my lord in on 11th.
This court.
This court, lordship. Same issue, lordship.
Then we list it on that.
Lordship. Otherwise, lordship, BTC or government of Assam cannot take a decision, lordship, by violating the provision of Article 16.
I think the Supreme Court to some
Supreme Court
extent
is-
dealt with, last week, Supreme Court dealt with
Last
this
week also
issue.
in constitutional bench judgment, lordship, in September, lordship, they have delivered.
No, something happened in Supreme Court last week
Last
on this
week also,
issue.
Even Supreme Court, even lordship, Punjab and Haryana High Court.
Was
also
any
last-
order passed?
Lordship.
We have that order of the Supreme Court.
Lordship, I will press it. Lord,
We'll
any
find
letter.
out.
Lord. A constitutional judgment is there. Lord. And even three judgment also there Supreme Court recently. Lord.
But here they are not ousting, they are saying preference.
Preference, Lord. Whether that
The preference and total ouster will be different.
preference part also dealt with.
Preference, why preference cannot be given considering
Preference
something?
part also dealt with another constitutional judgment in 87.
They say you cannot give preference.
Lordship, that
That means across the country, it will be seamless.
Lordship, the view of the court is that Lordship.
Take a close look at it. What's the view is?
View of the court is even Lordship in the Madhya Bharat Lordship, that Madhya Pradesh Lordship, that issue was there. Preference is given only for Madhya Bharat student Lordship regarding appointment Lordship. That is
No,
judgment
but
of
this is going on everywhere. You
Lordship.
see, if you try to get admission in that government law college, Bombay,
Lordship.
which is a very sought after institute, 80% is reserved for this thing.
Instead of Maharashtra.
Hmm. That is still prevailing.
Okay.
I am not on the Marathwada
No,
reservation.
Lordship.
Marathwada reservation was
Lord-
dealt separately,
That separate issue Lordship.
but these are going on everywhere.
MP Lordship, but the Honorable Supreme Court dealt with this issue in a 1986 Lordship, the Madhya Bharat judgment Lordship. That was also Lordship for giving admission to a particular district of the Madhya Pradesh. It was also.
No, no.
Lord-
One aspect will be total ouster. Say you are not even eligible to come in.
That
Ha.
complete.
Other one will be preference.
Lordship.
Third method may be in the selection process, you put in such a condition
Lordship.
that a man from outside will have
That cannot be
difficulty.
entered, Lordship.
There are different methods of
Lordship.
doing it. Which one is illegal?
Lordship, that part.
One total ouster that I will not even entertain your
Total outside
application.
is a complete violation of 16 laws.
Ha. Other one is preference, like this
Preference.
one. Third one is, we are going to hold a written test and the test will be, or any kind of test, and test will be of such a nature that a man from outside will never be able to know.
My lord may examine it, Lordship, on 11, Lordship, we will also try it, Lordship.
My lord, in the chemistry department, they given the preference and appointed such candidate. They cannot do that, my lord. They cannot pick and choose. You will not.
No, you are in favor of inside candidate.
Favor of Lordship,
My-
BTC, Lord.
BTC,
Yeah,
outside should not come in.
My
So
lord,
now you are arguing the other way around.
No, my
You are
lord.
giving,
in the chemistry department, a candidate was selected was from BTC by giving her preference. In the physics department, they denied the petitioner.
this is physics.
In another two department also, Lordship, that was put to silence on 11, Lordship has picked it. My colleague B. Monto is appeared in this case. He is the. We have no issue, just I have pointed out the Lordship.
No, this is not a such easy an issue
No,
which can be dealt with in one stroke of pen or in a single line.
Lordship.
There are various facets to this
Lordship.
issue. So therefore, we want to know what the Supreme Court has provided.
Lordship, on-
And whatever Supreme Court provided, we'll try to understand it and follow it accordingly.
Probably last week, Lordship, the Punjab and Haryana High Court, Lordship, it is a reservation of 75%.
No, I read it somewhere
Lordship.
that something was
Lordship.
given last week by the Supreme
Lordship,
Court. Produce everything
Lordship,
and we'll try to examine the
aspect,
what the Supreme Court had actually provided
Lordship,
and try to
Lordship.
put it in accordingly.
My lord, on 11, Lordship, will put it.
This one 11. Till then, don't make any appointment or you are not yet to reach that stage.
Let it come on 11, my lord.
Till then, don't make this thing final publication. You process it, don't make the final publication.
Would have the leave of the court.
We are not putting it in an order, but we understand Mr. Bora will
Lordship,
My lord,
communicate.
my lord, it may be part.
Then we'll have to,
My,
Mr. Boyce, then we'll have to hear everything. If I put it in a judicial order, it has to be with a reason, then I have to hear you, both of you.
come on,
This is only a in-between arrangement
Lordship.
with the authorities.
his
Yes.
assurance may be,
I will. I'll be.
Mr. Boyce,
my lord.
any judicial order has to be backed by reason and a decision. Otherwise, we just can't list on Ilway spread for along with WPC.
3.5 kilometers. So the villagers, we are the guardians of the students, Lordship, our
You want to separate it now.
Lordship.
Merger, you are not happy.
No, no, lordship.
You have to travel 3 kilometers.
Yes. As because in the meantime, lordship, the river erosion was, river was rebuilt, the lands were rebuilt and we already shifted to our original village, lordship. Earlier, due to erosion, lordship, the school was shifted about 3 kilometers away from the original village, lordship.
Where is this order? 14/9/2023.
Page 16, lordship.
So 1746 Katlamari is merged with 222 Katlamari Part 4. Both are LP school.
Yes.
And your grievance is distance is 3 kilometers.
Now, lordship, the original village is Kaplamari Part 3. Due to erosion, the school shifted temporarily to a place about 3 kilometers away from the original village. And from that lordship place to the base school lordship, half-kilometer distance. But it becomes almost 3.5 kilometers to the original village. And
No,
we
he
are
is
saying-
already merged.
No, lordship,
So what would have happened in the original village is
lordship,
no longer relevant
lordship. But
because
lordship, already.
merger already taken place or not?
Lordship, as per our information, it was not taken, so there is an interim prayer also, lordship.
I'll have to take instructions till then, my lord, will maintain it.
Will it violate any of the condition of merger?
Lordship, that is clause 13, lordship,
Page number?
Page 27.
27, lordship, clause 13.
27. So it is within 1 kilometer, but this will be 3 kilometers. 3 kilometers you cannot merge.
That is their contact.
And, no,
Will require.
forget other than their contention, LP school means what? Students will be aged about what, 4 or 5 years. Send a 4 or 5 year kid to a school 3 kilometers away when the school was available nearby. I think it's little illogical to merge
Yes,
this.
in fact, the office member also does not permit.
Here, MS R. Chaudhary, and Mr. B. Kaushik for the Elementary Education Department, MS D. Varman 4, DD Varman 4, 3 and 4. For the Deputy Authorities and Deputy Commissioner Dhubri. Notice 6 weeks, extra copies 3 days by the order dated 14/9/2023 of the District Elementary Education Officer Dhubri, the 1746 number Dhorbari Katlamara LP School had been merged with 2222 number Katlamara Part 4 LP School. But you stated that the distance between the two schools, between the original school and the base school to which it is merged would be about 3 kilometers. Clause 13 of the notification dated
Office member to the 3rd of August.
3/8/2021 at clause 13 provides that if 2 or more LP schools are located within a radius of 1 kilometer, then these LP schools may be merged. It appears that in merger of 2 LP schools which are at a distance of 3 kilometers had violated clause 13 of the OM dated 3/8/2021, as well as if the merger is allowed, the LP school whose students would be at a very tender age would be subjected to an inconvenience of requiring to go to a school which may be at a distance of 3 kilometers. From both points of view, the order dated so and so shall remain state until further orders.
Apply.
17 and 18 for admission.
In this case, may I refer some time, lordship, to submit the inquiry report, lordship, the concern.
How much time?
After 2 weeks, lordship.
2 weeks time granted on the prayer of Ms. MS D.D. Burman for production of the inquiry report.
Yeah, I did.
Regarding item 17, but item 18, my lord, he will also kindly see the inquiry report. Item 18.
18 is different.
Same, but item 17, J. Salinda, another thing, and item 18. Already in appointment of the petitioner has been cancelled by conducting several inquiry, my lord.
No, that is okay. Now, are you unhappy with this order, prayer of adjournment? No, then hear you after 2 weeks.
That may be,
Did,
because I have not proper amendment, although order is there.
okay.
19 December. Item 19.
Yes, Mr. Chaudhary.
My lord, in this case, Mr. Gogoi has received certain instruction.
Sorry,
Mr. Gogoi has received certain instruction, my lord.
you want to file affidavit?
Yes, my lord. So sometime maybe.
Only one thing I'd like to submit, Lord. Instruction they received way back, probably 6 months ago. They did not file any affidavit. And this matter, my lord, covers your lordship's judgment, as well as one judgment of Justice, Honorable Justice Manojit Goya, where your lordship appeared as a counsel. If I can show that two judgments, my lord.
No, you show it, we'll hear you.
Hello.
But he wants to file affidavit. How can I deny him that? How much time will you need?
2 weeks, my lord.
2 weeks. 1 week. Okay. It's stated that the instruction is available and some time will be required to file affidavit. 1 week time granted to file affidavit to the authorities in the higher education department. Please don't stress.
If your lordship fixes it. I'm a bit.
Item 20. He got it.
Yes,
My lord, petitioners, my lord, they are great for employee, my lord.
you have to file affidavit.
My lord, we have got
Mr. B.
Receiving-
Kaushik for the elementary chair prays for
4 weeks time.
4 weeks.
My lord, the
So
extra copy has not-
2021 matter.
extra copies they have not served us, my lord. We could not take steps for
Then till now not served.
till now. They have.
Don't file the affidavit.
I've seen the
It
record
stated
of-
that affidavits could not be filed by the respondent as because extra copies had not been served. List again.
21.
Others, in this case, some records were called for, my lord. That has not been received yet, my lord. My lord, let the matter be come up on fifth, my lord. I will produce the record.
On the premise as thought, I have list on.
Okay.
22. Hello. After it.
2 weeks time maybe. Item 20.
On the prayer, Mr. B. Kaushik for the elementary education.
My lord, tell him.
2 weeks time granted to file affidavit.
23. Borrow.
on instruction, I'd like to not press this matter.
Not to press.
Borrowed, right?
Your name,
Is it?
item number 23. Mr. E.J. Ahmed, land counsel petitioner states that there is an instruction from the petitioner not to press with this writ petition in the present form. In view of such statement, writ petition closed. Any liberty?
24. Borrow.
None appears for the petitioner adjourned.
25.
25. None appears adjourned.
Item 28. 26. 26 at all.
Yes, Mr. Bhuya.
May I please your lordship? My lord, in 26, an order of promotion is under challenge. And the private respondent had been appointed in violation of this.
Order of promotion, but no affidavit is there. I think one affidavit by somebody.
By the private respondent had been
Azizur
filed.
Rahman. Do you need the affidavit of the state or the records will do?
Record can do, my lord. Matter of seniority dispute only, that I am the senior and I am entitled. Now they are saying.
It's stated by Mr. E.R. Bhuya, land counsel petitioner, that the matter involves the question of seniority between the petitioner and the respondent number
Five.
five. Respondent number five has filed affidavit, although none appears today. But the state has not filed affidavit. It is stated that the production of the records of the proceeding relating to the promotion would be sufficient for an adjudication in the matter. In view of the above, the records of the proceeding by which the promotion was given to respondent will be produced before the court on the next returnable date.
Item 28,
Thank you.
Please, my lord. My lord,
None appears for the petitioner when the matter is called. Heard Mr. S D, also heard. What is this matter?
My lord, we were praying for directing the Director of Higher Education to approve our appointment to a sanctioned post. That order has been passed, my lord.
So now,
My lord,
concluded a formal approval of Shailen Sharma was pending since for which proposal is director on hence after the approval of Senator interposed is accorded with effect from so and so with all consequential benefit as per the order of the High Court dated 19/11/2023 in WBC 37. This is another
yes,
petition.
my lord. By that order, our suspension had been.
Okay, now we can close this one.
Yes, my lord.
It's stated by Mr. S. Dale and counsel. Your name appears.
No, my lord, I am appearing on behalf of on the instruction of Mr. S. Bodhak.
How can I do it? I cannot close a petition.
Okay, then your lordship may kindly take it.
Ask
after
Mr. Bothakud to come, we'll close it. We are technically speaking, if you don't appear, I can close a petition.
Lord, I will inform Mr.
I can hear you and pass some favorable orders, but I cannot close it.
Lordship, I will inform.
29,
Much obliged.
Last 10 years, Milord, we are deprived from the Milord slurry. Now, our services have been provincialized in the year 2013. And
Yes,
because of-
who appears? Mr. Pukon, 20 years salary is not paid.
BTC is the necessary part of
Where is BTC?
BTC not relevant. Milord, Lordship kindly see page 127 as per the High Court.
No, today what can I do, Mr. Mondol?
Milord, there is the inquiry report in terms. of the
127.
Yes, 127, Milord.
127.
Yes. It says, Milord, school is existing. And this court's, Milord, honorable court
Just a
order is
minute.
there.
Just a minute. This is by Ahom Sarvashikha.
SSA also will be required.
Mr. Pukon, all are parties, I understand, but what do you have to say?
But as far as the
What is the grievance?
Milord,
Prayer? Why the impugn order dated 15, 22 and 22 by the director? By what happened by these orders?
Milord, the order passed by this honorable court, Milord.
Oh, no. By these orders of 29/9/77 and 25/7,
Yes.
which you have challenged,
Milord,
what had happened by these orders? Your salary was rejected.
Yes, rejected.
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 So now you want to challenge this order.
Yes.
Rejected on what ground?
Ground, Milord, the dash code is, Milord, was mismatched. Dash
There is a
code was-
mismatch. Show us one of the order.
Yes, now Lordships, kindly see the order at page 107, Milord.
107.
Yes, Lordship's order, Milord.
107 is a High Court order. We want to see the impugn orders.
Impugn order, Milord.
Mhm.
Impugn order page, Milord, last page, Milord. Page, Milord, 131, Milord.
131.
And property part, Milord.
page 133, from second para, decision. In view of the above facts and circumstances, it is seen that MD SSA Assam conducted hearing of the petitioners and issued order dated so court case number so dated 7/7/2023, disposing the prior petition dated 1/3/2021 with a view that it is not possible to modify, rectify it. as
Just a
that-
minute. Now you are relying on 127.
Madam. And earlier direction of Honorable Court, to verify whether school is existing or not. And on inquiry, it is found it is existing, since 1997, 99.
Mr. Fukan,
Sir.
let it go back to the director.
Sir.
Because this one is dated 8/6/2022. Because after you pass the impugn order rejecting it, there is a report by the SSA that this school is a very located in a very remote area. Which is very backward both economically and educationally. There is no institution within 3 kilometers.
Hello.
Why don't you give them the benefit? So it's maybe so remote area, your DICE data did not go and reach that place. You are sitting in Guwahati and taking decision whether DICE data is there or not.
Hello.
The hand of the DICE data possibly was not that long enough to go and reach this extremely remote place. But there is a physical verification. Give them the benefit.
Okay.
Otherwise, it will be injustice to them.
We'll reconsider, madam.
It needs better. And that too without reverting to this DICE code and all. What is DICE code? DICE data. DICE data stores the information in a computer system.
Yes.
But the data is otherwise available outside. Outside data is fed to the computer maintains it. That is DICE data. If the outside data shows that this school actually existed, functioning, they are entitled to the benefit, whether or not in the DICE data or not. You can't take the technical view and reject it. For regular schools, I understand. But this is an extreme case. Yes, Mr. Chisti. He is possibly having little difficulty in accepting it also. Normally, we understand DICE data, and that is very relevant because it shows whether it's a fraudulent claim or it's an actual claim. And if DICE data is not there, it's a presumption that it is a fraudulent claim. But this one, SSA report, is in a very remote area in Kuklung Forest Range of Indo-Bhutan border, north to Chirang district. School is located in so-and-so village Boro Bazar, which is very backward, both economically and educationally. There is no education institution within 3 kilometers. So this itself is one of the reasons why this school should be given the benefit. Because they are the only school there in that area. I think your right to Education Act will be violated if you don't take note of this school. During my inspection, somebody arrived. I had an interaction with the assembly teacher and student, and I personally feel the necessity of the school in that location. See the report of the SSA. He personally goes one man. Huh. Oh, we'll ask you to give it. Give the benefit to them. One report is that you have gone only going by the modification of some database, DICE database, and rectification cannot be made that something had lapsed. We'll ask you to take a different route. We have to forget about database. What is database? Storage of input of data. If the information is physically available otherwise, for this school, make an exception, give them the benefit. Or else your Article 14 will violate. Judgment to come to us in. So, Chisti, I think there is a judgment. If same law is made applicable to unequals, it will violate Article 14. Here is a school which is in a very, very remote area in the Bhutan border. Socially, economically, completely backward. And you compare them with the schools in Guwahati and Nalbari and Jorhat and other places regarding DICE data. If we apply the same law to this school, which is class apart from the others, you'll violate Article 14. Make a deviation. If you want, make one further physical verification, we don't mind that. Huh. But SSA has done it.
June 22.
Oh, by now, situation will not change. A school which was remote in 2022 cannot be in the middle of a city in 2023. And everything is there, you see. They have land, it was established in 1999. Attendance is teachers' attendance registered from 89 to 22. Students' attendance registered from 99 to 2022. What more do you need? This is the information you would have stored in your DICE data otherwise. Had this school must have been forgotten by everyone when you made the DICE data. Everything is there. So why do you don't give them the benefit? You don't need any further inspection also, unless you say that this SSA had made a fraudulent inquiry. Then it is your internal matter. Heard Mr. M.U. Mondal, learned counsel for the petitioner, also heard Mr. E. Should I put Mr. Phukon's name or your name? Because it will have some consequence. Somebody may ask Mr. Phukon that why didn't you argue the matter well? Because we are deviating from the regular law. His name.
Yep.
Mr. A. Phukon for the Elementary Education Department and Mr. B. Chaudhary for the SSA, MS D.D. Burman for the Deputy Commissioner. Deputy Commissioner Chirang.
Here I will be appearing for
BTC. For the BTC. SSA who appears?
SSA. That also.
You appear for the SSA as well as BTC. It's a regulation under the provision under the 17 Act.
11 Act.
11 Act.
Page 37 lot.
Do it under the 17 Act.
Under the 17 Act.
Do it under the, give them the benefit under the 17 Act.
17 Act.
11 will again make it more complicated.
Now,
Don't want.
now it's fine, Miller. It's fine. But everything is Miller done under the.
Then we'll hear you. Okay. We'll hear you then.
Let it be, Miller.
When do you want?
No,
We'll fix up a hearing if you want.
Now, is your lordship, my lord, desire, lordship?
No, no, you wanted to make further hearing. If you want, we'll hear you, but we'll have to fix one more date.
No, my lord, it can be disposed of.
Yes, yes. First writ petition is instituted. By Jivan Chandra Burman and Manjit Kumar Brahma, both being teachers of Beltoli Novojyoti LP School, which is a mixed medium school. It is stated that petitioner number 1, কি নামটা কইছিল? দুটা নাম কলো নহয়. Petitioner number 1 had been working as the head teacher with from 16/11/1999, and a petitioner number 2 has been working as an assistant teacher from 27/2/2022. The school was initially allotted the DISC code number 0111-206 for the period 2009 to 10 till date. By a later order dated 1/11/2012, the school, along with its DISC code, was bifurcated and brought under the purview of the Chirang district. Upon bifurcation of the erstwhile Bongaigaon district into Bongaigaon district and Chirang district. The claim of the petitioner was required to have been, petitioners for provincialization was required to have been processed under the Assam Venture Education Institution Provincialized Services Act 2011. But the matter could not be taken further inasmuch as the DISC code, DISC data regarding the school that is required to be, which is required to be maintained, was not maintained in the appropriate, in the required, in the appropriate manner. In the circumstance, orders dated 29/9/2015, 7/7/2022, 25/7/2022 were passed by the Director of Elementary Education, Assam, by which the claim for provincialization of the petitioners stood rejected. Where is the order of 29/9?
It's 74, page 70.
74.
75.
74.
In the order dated 29/9/2022, the claim for provincialization under the Act of 2011 was rejected by providing that the petitioner school, namely Beltoli Novojyoti LP School, which was under the Borobazar Educational Block of Chirang district, did not have a DISC code for the year 2009-10 or prior to 2009-10. Where is the other order?
Order of the Malad, page 129, Malad.
129. 129. Not 129. Aha.
Yeah.
There must be in between one more order. 7/7/2022, 19. Look at the prayer. You have referred to 3 orders.
In between, Malad, report is there.
No, no. Look at your prayer, Mr. 7/7/2022. Huh, take it. By the order dated 7/7/2022 of the Director Elementary of the Mission Director of Assam Sarva Abhijan Mission (SSA) Assam. An order was passed that the DICE data is maintained by an institution named NUPA, NIEPA, bracket National Institute of Education Planning and Administration, New Delhi, under the Government of India in the Education Department. And therefore, it was not possible for the authorities under the SSA to modify or rectify the DICE data in respect of the school Beltoli school. By where is the other order? Page 131, I think.
131.
By the order dated 25/7/2022 of the Director of Elementary Education, Assam, second order to SSA, first order to Director, third order to Director. The claim for provincialization of the petitioner school was rejected by taking a stand that it was not possible for the authorities, either in the SSA or in the Director of Elementary Education Assam, to modify or rectify the DISC data, which had already been frozen by the Institute NUPA Naki, which functions under the Ministry of Education, Government of India. Being aggrieved, the present writ petition is instituted seeking direction for setting aside the aforesaid 3 orders dated so and so, and also for a direction to respond authorities to provincialize the services of the petitioners. We take note that the process for provincialization of the petitioners was undertaken under the Act of 2011, but in the meantime, the Act of 2011 had been declared to be ultra-virus by the judgment of this court dated so and so in. Yes, Mr. Chisti, give that information by the judgment dated so and so in WA so and so. That ultra-virus of 2011 Act. Upon the Act of 2011 being declared to be ultra-virus, the respondents in the state respondents had enacted the 2017 Act. As nothing further had been carried forward, as the matter had not been carried forward, sufficient enough to invoke the provisions of the Act of 2011, we are of the view that a claim of the provision of petitioners would now have to be considered under the Act of 2017. But at the same time, we also take note of the reason provided in the 3 orders dated Omuk, Omuk, and Omuk for rejecting the claim for provincialization. A reading of the 3 orders makes it discernible that the only reason why the provincialization of the petitioner's school, of the petition services of the petitioners was rejected is that the Beltoli Omukti school did not have appropriate DICE data for certain period prior to the year 2009. Whereas it is also an admitted position of the respondents that there was an anomaly in maintaining the DICE data in as much as the school which originally located in the Bongaigaon district was within the Chirang district after the bifurcation. And during the bifurcation, there was certain miscommunications between the authorities. Be that as it may, we take note that the provincialization was refused as because the complete DICE data information is not available. To justify the rejection of the provincialization, Mr. A. Phukan, Land Counsel for the Elementary Education Department, relies on which provision requires DICE data? 17 Act. One particular section is there. Which page number of this book?
P112.
3.1. First give the page number, then give the section number. So 111.
Enrollment shall be verified with the data as per DICE code
Is the rule number?
12.
Section 12.
No, it's
কি বলো?
312.
Which section, Mr.
312, Your Lordship. The
Three-
enrollment shall be
312,
12. Roman 12. Page 111.
page number
111.
311.
111. The last paragraph.
On relies upon the provisions of section 3 bracket 1 bracket Roman 12 of the Act of 2017, which provides that the enrollment, that for the purpose of provincialization, the enrollment shall be verified with the data as per the DICE code of the year 2009-10 or before, as may be available in the records of the NUPA. From such point of view, we are in agreement with the submission of Mr. A. Phukan, Land Counsel for Elementary Education Department, that as the appropriate DICE data is in respect of Beltoli School is not available, therefore further process of provincialization cannot be carried forward. But at the same time, we also take note of the report dated 8/6/2022 of the what is this? Why these people put this seal on one on top of the other? You can read neither. One is some printed designation and top of that one black seal also. Page number 128. And you cannot read either of the two now.
District mission voting
Chirang.
By the District Mission Coordinator SSA Chirang, made to the Executive Director SSA. The said report is pursuant to an inquiry conducted by the District Coordinator upon personal visit of the Beltoli Novosity LP School made on 4/6/2022. As regards verification of the reports and records of DISE code for the year 2009-10. The report of the district is extracted as below. Reading of the report makes it discernible and explicit that the school was established on 17/3/1999. It has land of 2 bighas in the name of the school. The school has an SMC along with building. What is more relevant is that the teachers' attendance registered with effect from 17/3/1999 to 4/6/2022 was verified and accepted by the district mission committee to be in order. The students' attendance register from 17/3/1999 to 4/6/2022 was also verified and found to be in order. What is DIC data? Where is it defined? Where do you define the concept DICE code or DICE data? I think somewhere this concept is there.
Lordship, it's at page 103,
Definition,
definition at
Maybe,
page 103, Lordship of the.
possible. Uh,
Dias means.
Yes, right. Section 2I of the Act of 2017 defines DICE code to mean DICE code to mean the District Information System for Education Code prepared by the Sarva-Shiksha Abhiyan Assam and as available in the records of the National University of Education Planning and Administration. Yeah, what is DICE data? DICE data, what is DICE data?
Dias data, Lordship, is the annual data. Lordship, on the one affidavit was filed by the SSA on in the yesterday's case. Lordship, it was given annual data received by the.
It is stated on the basis of an affidavit by the respondents in the elementary education department that the DICE data is the
Annual data
collected regarding the teaching staff
Ah.
and the enrollment of the students in a given school of the respective years for which the school is claimed to have been in
and it's
existence,
submitted every 30th September of every year.
which is required to be submitted periodically.
Right.
The relevance of DICE data is understood in as much as if the DICE is the aforesaid information is included in the DICE data, it's a prima facie satisfaction of the authorities that the school concerned had the required teacher enrollment for the years for which it is claimed to be in existence. As well as the enrollment and existence of the students of the school for the period of its existence, more particularly for the period prior to the year 2009-10. In other words, the DICE concept of DICE code and DICE data is the records of the information, aforesaid information regarding the school maintained in an electronic form under the control of the SSA and presently maintained in the Institute NIEPUA. From such point of view, absence of the data, absence of the information regarding a school in the DICE data can also prima facie construed to be a situation where the school concerned may not be in existence. But in the instant case, what is further noticed is that as per the report of the district so-and-so dated 8/6/2022, it had been clearly stated that the school, Beltoli Omuk school, is located in a very remote area in the Kuklung forest range in the Indo-Bhutan border area. And the school is located in number 1 Dangsiapara village under Borobazar Education Block, which the mission director cum coordinator had reported to be in a place which is very backward, both economically and educationally. But what is most relevant is that the school is the only educational school within a radius of 3 kilometers in such a remote area. The district mission coordinator during his inspection had also had an interaction with the members of the SMC, teachers, students, and a definite view is expressed that there is a necessity of a school in that locality for spread of education. Are we concerned? The Right of Children to Free and Compulsory Education Act 2009 under section 3 provides that every child of the age of 6 to 14 years, including the 14 years, shall have the right of free and compulsory education in a neighborhood school till the completion of his or her elementary education. In other words, it is a right of the children of the locality where the school is presently located to have, it is a statutory right to have free and compulsory education. And it is further, and the report further states that it is the only school in the locality within a radius of 3 kilometers in an extremely remote area in the Indo-Bhutan border, which is backward both economically and educationally. It is also a distinct possibility that non-recording of the information regarding the school in the DIAS data, as had been arrived at by the authority, Director of Elementary Education and the authority SSA in the 3 orders dated so and so, ago 3টা যে আছিল কি করলো that it is because of the extreme remote location of the school in the Indo-Bhutan border inside a forest area, which is economically and educationally backward, to be a reason as to why the data could not be maintained properly in the DIAS data maintained, that the information school could not be maintained properly in the DIAS data. As already held, DIAS data may be giving a prima facie indication of the existence of the school, its teachers, and the students. But, full stop, from such point of view, the provisions of section 3(1)(12) of the Act of 2017, that only such schools would be subject to provincialization in respect of whom the information is captured in the DIAS data prior to 2009 and 11. People look for a sentence too. Yeah, we say, yeah, we said আগৰ sentence পঢ়িব লাগিব last 2 sentences for us.
has been arrived by the Director of Parliamentary Education and Associate Assam in the exemplary orders that it is because of the extreme remote location of the school in the Indo-Bhutan area inside the forest area, which is currently an education.
Backward, ঠিক আছে তার পিছনে next to Omo. Full stop. But having regard to the factual situation with reference to the report dated so and so, 8/6/2022, the Beltoli school is located in an extreme remote area inside the forest range in the Indo-Bhutan border, which is backward both economically and educationally, and it is the only school within the vicinity in the area. Last sentence. Comma. We have to understand that the Beltoli school being a Beltoli school which can be accepted to be a reasonable classification with an intelligible differential with the object at hand from the other regular schools which are subjected to provincialization under the Act, comma, if the same applicability and meaning of section 3(1)(12) is also given to the Beltoli Omuk school, comma, there would be a violation of Article 14 of the Constitution in as much as two classes having a distinct differentiation with each other would be subjected to the same law. This proposition had been laid down by the Honorable Supreme Court in paragraph so and so of one judgment is there around 94 or 97, that if two classes of people are subject to the same law, it will violate Article 14. Furthermore, the factual depiction as per the record is that all the information that are otherwise ought to have been stored in these DICE data is verified and accepted to be available in respect of the ASO school, meaning thereby that the purpose for maintaining the DICE data in respect of Beltoli school in the facts of the present case is otherwise satisfied. And it is only a technical aspect that the data had not been included in the DICE data maintained by the authorities. From such point of view, without giving a strict technical interpretation, the requirements of section 3(1)(12) of the Act of 2017 is also satisfied in the present case, in as much as the required information which ought to have been stored in the DICE data is otherwise applicable in respect of the petitioner school. Thirdly, we also take note that there is a conflicting situation that on one hand, section 3 of the right to free education provides for free and compulsory education to the children in a neighborhood locality where there is only one school available in the neighborhood locality, which also is in existence from 1999. And therefore, by adopting a strict technical interpretation of section 3(1)(12) of the Act of 2017, comma, the provincialization which otherwise the school is entitled should not be refused. From such point of view, the 3 orders dated so and so set aside. The respondents through the director element is directed to process the claim for provincialization of the teachers of Beltolier School as per law. Provided otherwise, the two teachers are entitled, and it should not be rejected again merely on the ground of the dice data being not available. Over. Anything more? Any further clarification? It's clarified that the present adjudication is made in the peculiar facts and circumstances of the matter regarding the extreme remote location of the school in the Indo-Bhutan border in a forest area where the school being isolated from others may not have been subjected to the same treatment as the other schools in the state may have received. And as such, apart from the determination or the question of law, the direction contained herein may not be a precedent. But the law is binding, not the direction.
May I refer to only one page, page 37.
Petition dismissed.
We are already provincialized. That clarification may be.
Then why are you before the court?
Because our salary was stopped because of mismatch of dice.
By referring to page
37.
37, Mr. M.U. Mondal and counsel for the petitioner states that the school was already provincialized, but it is only the salary which is not being paid to the petitioners. If that is so, as the school is otherwise entitled to be provincialized as held herein above, the consequence thereof would be that the teachers would also be entitled to salaries, and accordingly the salaries of the petitioners be also paid as per their entitlement within a period of 1 month to be done.
Notice not issued.
Lordship.
Notice is
Notice process, Lordship. Lordship, page number 28. And petitioner naming reflected Lordship, page number.
So what is to be done to them?
DLC rejected, Lordship.
Understand. What to do, Mr. Devrish? We hear it or you want to file affidavit? Your notice is issued. This is not in motion.
Lordship, what they have given is, Lordship. So let me have the instruction.
Instruction, what instruction? Instruction of what?
What they have, what the ground they have stated, your Lordship, is as per your Lordship, that in other matter, your Lordship, that that they have just given a general statement, your Lordship. They are comparative whether they have.
No, where is the DLC?
Lordship, in page number 29, Lordship.
29 last para.
Last para, Lordship.
29.
There are 15 number of proposals received for the post of grade for the names of the candidate.
After detailed study of proposals, especially on basis of family economic condition, landed property, number of dependent, proposal of sheet were recommended against one number of vacancies.
Who is this petitioner?
I mean to Gogol, Lordship.
Mintu. Why Mintu was rejected?
Better economic.
Remaining 11 could not. So they're given a good reason. This was I was telling you. If you take this into note, then I cannot interfere straight away. But if you don't do this, you do something different. Our work is very easy. You file the affidavit, produce the records. It is noticed that DLC in its meeting dated 17/11/2015 had rejected the claim of the petitioner for compassionate appointment by providing that on an inter-se financial comparison, the petitioner was found to be economically better off. To examine the correctness of such conclusion, the records of the proceeding be produced before the DLC be produced before the court, as well as any affidavit that the deputy commissioner intends to file may also be filed. List after 2 weeks,
4 weeks.
4 weeks. Yeah.
Apply.
33.
The petitioner is agreed by the order dated 7/3/18, by which his B.Ed degree has been
7. 7.
by agreed by order dated 7/3/2018, my lord. There is an annexure 6, my lord, page 30.
No, today what is to be
Of
done? Have you filed your affidavit? Want to file? Sorry.
We had undergone the B.Ed course, petitioner had undergone the B.Ed course without permission, madam. Lordship is already expressed in that matter. So perhaps that will cover this. I just need some time
So we
to
can,
go through it if it is the same.
We can pass this order, or you want to
I'll just
examine?
go through that and the facts of this case.
Mr. R. Mojumdar, like also for the secretary prays for an adjournment to examine as to whether the claim of the petition would be covered by the
So that details I will give.
by the judgment details. So list. When? After a week. Please continue.
34.
May I please, Your Honor? Lordship, matter is relating to compensation appointment. DIC rejected the case of the petitioner by stating that petitioner application submission of late submission.
Yes, so what
But
will
Lordship,
who appears respondents? Where is the DLC? Who rejected? DLC rejected.
Yes,
Page number.
Lordship, page 18. Come down. Not recommended for late submission.
Page number.
18, Lordship.
Inamul Masjid. Where is Inamul Masjid? Serial number.
Lordship, come down. C column.
See serial number.
11, Lordship.
Inamul Masjid.
Not recommended for late submission. But Lordship, come to page 12, annexure B.
When did you make this application? Yes, Mr. Majumdar? There is a incorrect factual depiction. Man died in 13/2/2009. Authorities consider application to be 24/12/2014. But if you come to page 12, application, date of application is 29/6/2009. So that was within time, rejected on the ground of late submission. You examine this aspect, right? Third, your name, madam?
M. Roy.
M.
Roy.
Roy, M. Roy, Mr. R. Majumdar for the Secondary Education Department. Mr. B. Deori, learned Janiganda advocate for the state authorities. The father of the petitioner.
Late Idris Ali.
Idris Ali, who was the headmaster of Khoti Radhika Girls High School in the Nagaon district, died in harness on 13/2/2009. And on his death, the petitioner made an application for compassionate appointment on 29, please.
29/6/2009.
Let us do our work. Don't go on interrupting. If any wrong, point out at the end of the order, we'll correct it, but not in between. You go, yes, because if you go nattering, my concentration goes off. Secondly, he doesn't understand anything. Because they record only the sound. When two sounds come from two different sides, he cannot record either of the two. So please.
Sorry, Lord.
Commission appointment on 29/6/2009 as discernible from Annexure B at page 12 of the writ petition. However, when the application was placed before the DLC of which page is the DLC? Page 8. DLC of
16.
9/1/2015, it stood rejected by providing that there was a late submission of application. It is noticed that the DLC took the date to be 13/2/2009 and the date of application to be 24/12/2014, whereas on fact, as indicated above, the date of application appears to be 29/6/2009. In view of the incorrect facts being taken note of by the DLC while rejecting the application petitioner, the rejection by the resolution dated 9/1/2015 set aside, remanded back to the DLC of Nagaon district for a fresh consideration by taking note of Annexure B, page 12 of the writ petition, which apparently appears to be an application which was made on 29 related to the board. Will be placed before the next available DLC.
35.
May I please vote? My lord, the school has been amalgamated, my lord, in violation of office memorandum. My lord.
But today, what is to be done? You want to file affidavit? MSS, Tutial and counsel for the element place for how much time?
4 weeks, madam.
4 weeks time to file a prayer law, list after 4 weeks.
For some shorter time, may I pray for my lord?
It's a 2020-23 matter, hardly 1 month old matter.
Teachers have joined, my lord, in this school. Students are not getting classes, my lord. That is the problem.
They also have their own entitlement to file.
36 and 37 for orders.
On the first day, 1 month old petition, why we can't give them 4 weeks?
They were directed to file before 23rd.
It granted 8 weeks time to file affidavit. It's a necessary objection you are raising.
My lord, 4 weeks.
Don't be so over enthusiastic. You are dealing with one matter today. Madam must be dealing with at least almost all the matters they are dealing with their list. How can you bind them that in a matter which is hardly 1 month old, you'll have to file your affidavit within this time? There's no such reason for that. No?
Maybe 4 weeks.
Your inconvenience cannot be something to impose something on the others.
4 weeks. Public.
36 and 37.
Please, Your Lordship, on the last occasion, we were asked to submit an affidavit. So we have submitted the affidavit before the Honorable Court and
Sorry. That railway matter.
yes, Your
Hmm, hmm, hmm.
Yes, on annex, in annex 6, the letter from the additional deputy district commissioner.
So you paid the money, you know,
Yes, Your Lordship. And
Now,
so,
we have also received the instruction, entire amount has been paid.
paid. So now what is to be done?
Your
Now,
Lordship, we are withdrawing.
so far as their appeal is concerned, their appeal they are withdrawing. So
You are
far
not
as-
pressing with the appeal.
Yeah, so far as our revision is concerned, we challenge the order passed by the executive court of putting the office or account attached
By?
by the executing court, my lord, district judge. So that order has been set aside now because
It's already set aside. So
Like,
now today, what do I do? I
so-
close the appeals and taking note it is paid.
And
And whatever money is paid,
Yeah.
the deputy commissioner may do the needful to disperse it amongst the lawful claimants.
disburse also.
Disperse also.
Also, now everything has come on record, man.
Yes, Your Lordship.
That is why the respondents are not appearing.
Definitely. We
As
have
your
to,
as your lordship indicated on the last revision. And so far as our revision is concerned, my lord, we challenge the order because the ADC at that time, on the basis of their application for execution of the order,
no, definitely, when the office of deputy commissioner is attached,
yeah,
it's a inconvenience for the public also.
Yes. so that order has to be set aside by your lordship.
Attachment order,
Yeah,
it's still existing.
still we challenge in the revision, there is a stay by this on court. By an interim order.
How many appeals are there? Only one appeal.
Yes, one affidavit.
Third, Ms.
M. Chatterjee.
M. Chatterjee, Land Counsel for the appellant, it LA appeal 0851 or DD, huh? কোনখন আহে দিলে কোনখন 3617 Third, Mr. D. Mojumdar, Land Counsel for the Deputy Commissioner Dhubri. Anybody else? For whom do you appear, Mr. Singh? You are with him, assisted by Mr. J. Singh. The interlocutory application is for condoning the delay of 1849 days in filing the accompanying LA appeal bearing filing number 4851/2018. The appeal is instituted against the judgment and award dated 18/1/2012 of the learned district judge Dhubri in LA case 16/2009, arising out of original LA case number 2/2004-05. Stop. It's noticed that the application for condoning the delay is pending for almost 4 years. Where notices were issued on 18/11/2019. Apparently, inasmuch as notice served or not on the landowner,
Yes, Your Lordship.
it was served.
Yes, sir.
Apparently on the admin pending, so apparently not again. It is stated by means of an affidavit filed on
24/11.
24/11/2023 that the entire awarded amount as per the judgment ordered award dated so and so in LA appeal so and so had been deposited by the appellant railway authorities before the Deputy Commissioner Dhubri. And the Deputy Commissioner Dhubri in turn had dispersed the amount to the lawful claimants. It's okay, Mr. Majumdar? Mr. Majumdar, is it okay? Disperse the amount to the lawful
Yes, yes.
claimants.
We want to be informed.
From such point of view, the railway authorities do not intend to press with the LA appeal any further. Accordingly, no order required to be passed in this interlocutory application for condoning the delay in filing the accompanying appeal. Interlocutory application closed. Appeal কিবা order দিব লাগে নেকি নালাগে? The registry closed. তাৰপিছত আগত লিখিব, the registry was not required to register the accompanying LA appeal and may record room যাব তো বোধহয়, I think. And the appeal may be placed in the record room. Second, I had to keep 4298 for what purpose?
Similar order may be passed here.
No, we can't pass similar order. What is the one is for condoning the delay?
Yes.
We have passed the order. What is the other one? Why have you filed?
Yeah.
Appeal was filed by them, revision was filed by the collector.
No, that appeal
Disposed of.
gone,
And the
IA gone. Now, what is the second IA? IA 4298. Union of India. Why did you file this appeal? For stay of execution. 82 লিখিব, heard. And the interlocutory application is under section 151 of the Code of Civil Procedure for stay of an office letter dated 5/11/2019 of the Deputy Commissioner Dhubri. Intimating that intimating the attachment of railway properties for recovering the awarded amount in LA case number, LA appeal number, agon number to diba. As the appeal itself is not required to be decided in as much as the entire awarded amount had been paid and disbursed to the lawful claimants. We are of the view that the present application for interfering with the letter dated 5/11/2019 of the Deputy Commissioner Dhubri is also not required to be adjudicated upon. I closed. That's Aru ase naki? Aru eta I say CRP to 40/2020. But we'll also direct that civil court to issue process against the persons who had obtained this order of attachment
For not
for
informing.
not informing the court. I think it is necessary.
They should have informed the.
Once they have attaching the office of the Deputy Commissioner,
They cannot keep quiet.
and
After getting the.
after getting the money, just run away from the scene. This is, I will direct them to issue notice to them to take appropriate action under the
Yes.
law.
District judge.
Heard Mr. D. Majumdar, learned Additional Advocate General for the petitioner,
Collect.
for the Collector Dhubri District, petitioner, Collector Dhubri District. Railways is not a party here, na?
Railway is not.
Ah. notice is served on this thing. This respondent has notice been served. Because they are not even appearing here also, that's why I'm
Here also
asking.
they are not.
I have the notice been served.
Office note I have not. Okay.
Nothing is there. Can you tell us where the notice, because if notice is served, they are deliberately staying, we make that observation we want to make.
Or lordship can do one thing, well, subject to what I find. This
No, no.
because of this revision.
Certain conduct should not be taken so lightly.
No, your lordship may directly district judge, at least if not here, even if they're not.
No, we want to observe that also, that here also, whether the notice served or not served. Don't make out anything.
No indicator.
Full stop. This petition under
227.
Article 227 of the Constitution of India has been instituted by the District Collector Dhubri against the order dated
7/9/19.
page number
Page 48.
48 against the order dated is it 48?
Page 48.
Seven 9/2019 of the learned District Judge Dhubri in LAX execution, LAX case number 02/2015.
And one more similar order passed on same date, page 52
and the order dated
same date, 7/9/2019.
and another order dated 7/9/2019 in LAX case number 03/2015. Full stop. The LAX cases 03/02/2015 and 03/2015 are for execution of the awarded amount as per the what is it called? Judgment and award dated so and so by the learned district judge in LA appeal case number so and so. Full stop. As the awarded amount had not been paid to the landowners instituted LAX cases 02/15 and 03/15 by the two orders impugned in the present application under Article 227. The learned district judge.
Page 50, last paragraph.
Now, which power he exercised? The learned district judge in exercise of
Under order 21 to 11.
under exercise powers under order 21 rule 11 had attached,
Page 50, last paragraph.
attached.
Revenue
The
deposit.
revenue deposit account number 8443C/D and 0101R/D in the Dhubri Treasury Office in connection with the aforesaid LA execution cases.
2 pages. Same order.
What are these two accounts? No, I think the districts also should be careful before you attach the account to the
Yes.
Deputy Commissioner's office. What are these accounts for?
I'll just find out. Account property for what? My landfill will collect over telephone documents.
Please. Means we are not very happy with the order also.
Yeah.
We are not happy with the thing and it should not be allowed to.
My landfill will collect.
You said order 21, rule 11.
Yes, no, it's mentioned in the order itself.
Order 21, rule 11 is oral application where a decree is for payment of money. The court may on oral application decree for the time of passing
Basically,
arrest the judgment holder prior to preparation of warrant.
it is mentioned in page 48, first paragraph.
Huh. This is something the judgment debtor is escaping. He is brought before the court and said that you pay the thing.
Basically, the execution petition. Actually.
Whatever it is. Full stop. কি করলো? Under 121 attached had the attached. What is the provision for attachment? It's another provision.
Yes, order 38. I think.
38.
8.
CPC এখন দিয়ে দিব ওটা। Attachment. Arrest and attachment before judgment. Or any other attachment? No.
Yes, even in the order 21 also it is there.
20?
1.
21. 21, where is it? Twenty-one has some more than 100 rules.
Yes. Order 21, rule 12 also be kindly.
Rule 12.
12.
That is the property of a judgment holder not in his possession.
Yeah.
Every attached for immovable property to contain certain.
13 is about
13 for attachment of any. These are the only three attachment of immovable property. Suppose the judgment holder has some land somewhere.
Yeah.
You can attach the land so that he cannot alienate the land for satisfying the requirement of the decree.
Order rule 41 also be kindly.
Rule 41.
It's 43.
43.
Attachment of movable.
Other than agricultural. Why I'm saying,
No, no.
to best of my knowledge, there is no provision to attach an account
48A is attachment of salary or allowance to private employee.
Every property that is attachable,
Yes.
the whole idea is once you attach, you bring it to your own control,
So that it can.
sell it off for whatever it is, and
Yeah.
the value that is you'll get,
Yeah.
you'll satisfy to meet the requirement of the decree.
Yeah.
But where is the provision to attach a government account? It's not there. It's not there. Keep a look. Attached. Order 21, Rule 11 is for execution of a money decree, where Order 21 Rule 11, 1 provides for arrest of the judgment holder prior to judgment holder for immediate execution, and Order 11 Rule 2 is for a written application for execution of a decree. No power of any attachment of a government revenue account, that too in the office of a collector or the deputy commissioner, is noticeable under Order 21 Rule 11.
Rule 52 and
52.
Attachment of property in custody of court or public office.
Account is not a property.
Account is not there.
He could have attached the office of the deputy commissioner, that the building I am taking over, selling it off.
That is that.
Full stop. The implication of attaching a revenue deposit account in the office of the deputy commissioner may have many serious impact. And it was for the learned judge to also apply its mind on the said aspect before passing any order of attaching a revenue deposit account of the office of the deputy commissioner stroke district collector. The purpose of attachment of immovable or movable property in execution of a decree is to take control of the property and, if necessary, use the value of such property to meet the requirements of a decree. Simply attaching the revenue account deposit of the office of the deputy commissioner could not have served the purpose of satisfying the execution of the decree, which was a subject matter, nor any full stop. In any view of the matter, it is stated by Mr. D. Mojumdar, learned senior counsel, that when was it paid? That as per the records, the awarded amount was deposited by the railway authorities before in the office of the collector Dhubri on so and so, and by the order dated so and so, the awarded amount had been dispersed to the lawful owners of the land which also includes the respondents herein, or in other words, the applicants in the LA execution case number 02/2019 and 03/2019. Even after the amount had been received by the landowners on so-and-so, it is rather unfortunate that the landowners had not bothered to inform the learned district judge for recalling the order of attachment. And the conduct of the landowners appears to be that they had simply disappeared from the matter once they have received the money. Full stop. They give the two dates, huh?
26/7/2021
Payment.
payment, 26/7.
And railways paid on? The entire conduct of the landowners stroke applicants in the LA execution case stroke respondents in the present revision petition appears to be
Irresponsible of course.
appears to be not only irresponsible, but also abusing the process of law. And more so, in view of the serious implication that the revenue deposit account in the office of the deputy the collector Dhubri had been attached. In the present revision also, none appears for the respondents, although the matter is pending for almost 4 years. It is only because of the interim order dated so-and-so passed by the court in CRP number so-and-so that the functioning of the office of the deputy collector could be carried forward, whereby the two orders impugned had been stayed. As the amount had already paid to the landowners, and it is the landowners who are evading further appearance in the court. Comma, and not being fair to the justice delivery system, comma, the two orders dated so-and-so are set aside. The learned district judge Dhubri is directed to close the LA execution case number 202/2019 and 03/2019 by following the due procedure of law.
2015.
In doing so, notice be also issued to the applicants in the LA case number so-and-so to explain their conduct as to why they have abused the justice delivery system in not informing the court regarding the payment of the amount and allowing a judicial proceeding to continue unnecessary and without any purpose. And that too with a possible detriment to the public interest, in as much as a revenue deposit account in the office of the collector Dhubri had been attached. Appropriate orders be taken under the law as may be advised after giving complete hearing to the applicants.
Revision is disposed.
Revision disposed, but that one I can dispose now.
No,
That one the district judge has to close. Let him issue notice and dispose it. And what are the two other IAs?
in the appeal, my lord.
In the revision, I think.
Revision, there is no IA.
IA
Yes.
839 and IA 841. What are these two?
I'm just. 839
Mhm.
is for.
Who filed it?
Who collector file it. 839 is for stay of the execution.
That is,
And 841 is for amendment.
in view of the order passed in the CRPA to DDO, no further order is required to be passed. I close. Same order in both.
Well, case number and all my land will provides.
Item 38.
But I think the district judge will have to formally close them.
Yes, sir.
We cannot. We are only against one interlocutory order that has been passed.
Lordship is insisting of the revision and appeal, not that execution.
Let him do in doing so, let him issue notice also.
Yes.
Yes, Mr. Saikia.
My lord, notice will go, my lord, to the newly implemented respondent number 4, 5, and 6.
Already impleted.
Yes.
Issue notice to the respondents number 4, 5, and 6, registered post 3 days.
4, 5, and 6, and to the 7, it should be sent by my lord, by Dusty Sakti, because he is avoiding.
Dusty is not available in contempt. Dusty is not available. We checked up the other day. Although 1 or 2 courts may have passed without being properly informed, it is not available.
Actually, we saw the previous notice also to him. Previous one number 7.
Have you served?
We have saw previous, I have annexed it, my lord, in the I.
Page number? IA which one?
I have 277.
Which page number?
Yes. Page number, my lord, 70.
Page number?
Yes.
7.
14, 17. 14. Yeah.
No, this is your informing the order violated.
No,
Where is the order of service? He is
Yes.
avoiding.
Page 16, my lord. Register execution.
Has he received it? No one knows.
My lord, that gentleman actually is avoiding.
Mr. Saikia, show us one material that he is avoiding, will immediately issue a warrant of arrest. But without that, we cannot do it. You show us one material he is deliberately avoiding, will has his personal appearance with a warrant.
Because this lady, my lord, who has lost her husband, is working for last 25
It
years.
doesn't matter whether he's a lady or a husband, but as long as the person is avoiding the court's notice, we have means to deal with it. But he have to show us the basic material that he is avoiding.
This SBI,
You order Dilu.
let the notice go, my lord. Let the notice go.
Issue notice by registered post on respondent number so and so. Also.
5, 6, and 7. 4, 5, 6.
5, 6, and 7 for it.
Obliged.
Who is this number 7?
Obliged.
Headmaster.
By name.
39.
This matter appears for respondent number 3 and 4, Lord.
Hmm.
Needed file an affidavit, Lord, some more time is required.
Mr. MP Sharma for respondent 3 and 4 prays for further time to file affidavit of origin. 2 weeks time granted. For the purpose.
Item 40.
Yeah, please.
Yes, please.
This incident matter is a review petition filed for reviewing the order dated 1/8/2022, which was passed in application petition 2 of 2021.
Hmm. It's a review petition.
Section 11, my lord, is not maintainable. Lord, order
Who
passed,
who filed the review?
the petitioner,
Petitioner filed review.
Yes,
That section 11 is not maintainable.
and no lordship, but our petition was that the appointment which was done was violative of Article 12, Section 12, Subsection 5 of the Arbitration Constitution Act. The order which was passed
Which order was passed, page number?
Page 18, my lord.
15,
19, my lord.
19.
Yes.
That order dated 1/2
1/8/22.
directs the authority. Mr. Rahman, the counsel for the petitioner. Earlier arbitrary appointed by parties namely S.S. Bansal had withdrawn. And just the seat submission made by petitioner. He always submits a substitute. Everybody may be appointed from amongst the panel by the. Directs the respondent to appoint a substitute arbitrator from the MOD panel. And this, according to you, violates?
Violates 12, section 12, subsection 5. of
Well,
the-
5.
Yeah, regarding the independence of the arbitrator.
Just a minute. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or subject matter of the dispute falls under any of the categories specified in the seventh schedule of this Arbitration Act shall be ineligible. Where is the seventh schedule? Hmm. Where is the seventh schedule?
Mine took it 78,
78,
page 78,
huh? Is 78 I have,
79.
but that seventh schedule I am not getting. Just a minute, I got the third schedule, so seventh must be there somewhere. Seventh schedule, huh? Seventh schedule, which clause?
Lordship, one.
Arbitrator is an employee, consultant, advisor, or has any other past or present business relation with a party. So the person in the MOD panel are all having that kind of a relation.
Lordship, hearing what we are stating is that entire appointment process is being conducted by the Ministry of Defense. So that they have a direct or indirect relationship with the Ministry of Defense.
Sorry.
Lordship, the persons who are in that panel are being appointed by Ministry of Defense. So directly or indirectly, they have a relationship with the Ministry of Defense. So they are the can respond.
High Court has a panel of arbitrators of the retired judges. If one of them is appointed, can you come and say that it violates 12(5), Schedule 7(1)? Because why? High Court has appointed those arbitrators, so they have relation. No, High Court has no relation. We only appoint. Similarly, then you have to challenge the entire panel list. That they, and you have to also establish that they have something. Just because one department prepares a panel list, that doesn't mean that he's an employee, consultant, advisor, or has any past or present business relation. It has to be business relation also. Suppose on PWD, there is a retired chief engineer. PWD appoints a retired chief engineer as arbitrator. Will it violate this clause?
But
you can't stretch it to this much.
What we are trying to propose is
But
that
Mr. Rahman has raised no objection. When the court asked you, are you objecting? You should have said this on that day.
he was under the impression that MOT panel of arbitrators is a separate arbitration panel, not under the Ministry of Defense. That was an error.
No, it's not under the ministry. It is by the ministry. There is a difference between by the Ministry of Defense and under the Ministry of Defense. Under, we accept it. Where is the panel? Let us see.
Page 292, my lord.
Two.
292 of their edition, running to 292, my lord. Rejoinder affidavit filed.
Instead of doing into all these things, if you have a serious dispute, why don't you go and get it adjudicated?
In fact,
Now, how many years have gone by into all this kind of
in fact,
litigation?
it's the arbitration by the Union of India, my lord.
Sorry?
That has been stalled. Arbitration by the Union of India.
Huh.
We have preferred the arbitration.
Ah,
There was a
so you are
termination of-
only trying to stall the arbitration, nothing else.
And Lordship,
So why shouldn't you dismiss with cost? So now, page 292. Applications have been invited for empanelment of arbitrator in military engineering service. So they are not under them.
Lordship, but our statement was
And my lord, clause C, my lord, we see page 293.
Huh?
There is qualification for the.
Everything is there.
Should not have been under disability affecting discharge of duty by virtue of statutory provision. So these all have been taken care of, and then the.
Lordship, what we are trying to.
No, I know what you are trying. Department wants an arbitration, you are trying to delay it as far as possible.
No, Lordship, I completely.
Understand? Now, how do you bring your case within clause 1 of the 7th schedule? The arbitrator, is he an employee? No. Is he a consultant? No. Is he an advisor? No. Does he have any past or present business relationship? No. If none of these 4 conditions are satisfied, just because a department maintains a panel of arbitrator, that doesn't mean this arbitrator, they are debarred from arbitrating in any manner.
But there is a rule, there is a subconscious bias that can be.
So,
Lordship,
subconscious bias, it's an abstract concept. No one can determine subconscious bias. Anybody can be subconsciously biased. Even as a lawyer, you may be subconsciously biased in favor of the respondent. Can you evaluate it? Yes, your client has given you a brief, but you have some greater connection with the respondents. So you want to subconsciously want to support them. Can we ever evaluate that? Then what's the means of evaluation? These are only
we are not,
presumptions in the mind.
our humble prayer is,
Your prayer is not sufficient. Your prayer has to be backed by some provisions of law. If I interfere in this one today, see the implication. All the panel of arbitrators that have been made by different authorities from time, everything will be go in one stroke. Have you ever understood the implication? If you find that the given arbitrator appointed is biased or ineligible in any manner, you come back to us. We'll deal with you. But on a general proposition, it will be very difficult to accept it.
our, legal, the entire process, which was supposed to happen, we parties, our entire situation is based on the independency perspective. If by any chance, there is a.
Definitely. And who asked you to enter that agreement? That it will be arbitrated by a panel of arbitrator of the department. Who asked you to agree to it? You should have refused that contract. That this clause we are having objection, we are not entering this contract. You could have done it. Just a council arbitration law is not that simple. Your name?
TR Sen.
TR?
Sen.
Sen. Yes, Mr. TR Sen. It's not that simple. You either bring your case with specific material, which will be within the 4 conditions mentioned in Schedule 7, Schedule Clause 1, or we dismiss your petition.
May grant me one more opportunity.
Come back on Monday.
Review is not maintainable. May I please rely on?
No, we'll let him have an opportunity first. Back on Monday. This on Monday. To enable the learned counsel for the review petitioner to produce any relevant proposition that a panel of arbitrators maintained by a government department would violate the provisions of clause 1 of the 7th schedule of the Arbitration and Conciliation Act 1996. And secondly, in what manner any such panel arbitrator can be brought within the concept of ineligibility as per the 4 situations referred in clause 1 of the 7th schedule.
Lordship, I think interim is that may be extended for.
What interim?
If the arbitration tribunals cannot proceed with the proceedings.
Sorry, interim order is against the concept of Arbitration Act. Arbitration is a faster remedy. Ordinarily, they should have gone to a civil court. To avail faster remedy, Arbitration Act has been brought in. Now, in this kind of a dispute, you are not even allowing them to even raise the dispute till now. In the guise of having faster remedy, you are making it even slower, because by now that title should have been, money should have been filed by now. Otherwise, you are preventing even that. But,
Much of that.
41.
This all frivolous petitions. Firstly, you must have taken a contract. Secondly, you must have not done the work. Thirdly, you must have siphoned away some public money. Now, to avoid it, you are getting all kind of technical objections. Maximum a legal brain can think of. And it appears now your thinking has gone beyond the acceptable limit.
Right, the content case, my lord, the notice has been issued. Last 6 October, my lord, the respondent took adjournment, my lord.
Sorry. 6 days they have taken adjournment. Very bad. What respondents? NJ Khatonier.
Mine.
So Mujumdar, any idea? NJ Khatonier. His allegation is time taken on 7 occasions, 6 occasions.
We have it after some time. He was here in the morning. It might be now.
After some time.
42.
This item, my lord, I have some information. We have filed an appeal against the.
You filed an appeal?
We have filed an appeal. I'll bring the details. Name.
It is stated by Mr. R. Mojumdar, also appearing for the respondent contenders, that the order which is alleged to have been violated, against the same, an appeal has been filed. Relevant materials will be produced before the court this next week.
42.
42, Hitway. Hitway 42.
41 আছে কোনটো আছে তেওঁটো এটো দিলে 41
42 to লৈ গ'ল আপুনি yes
Service report is awaited.
Await service report as with reference to office note dated 24/11/2020.
43.
Obliged.
Alam. এটা তো দিতে পারো তো
43 years.
8/9/23 service is complete, Lordship.
This what matter? Contempt matter.
Lordship.
Postal track. Not accepted. The office note of 8/9/2023 accepting notice of service in a contempt matter by relying on the postal track consignment report is rejected. Petitioner to take fresh steps on the respondent
No, no.
concern.
Order dated, Lordship, 8/9/23. Lordship,
Madam, we are right. You are yet to look at the order. The order is before us when we are dictating it.
Lordship, similar matter, Lordship, in item number 44, Lordship. That on that order, Lordship, this part is writing, Lordship. Item number 44, Lordship.
Madam,
Orders-
we are rejecting the order of the registry, accepting service of notice in a contempt petition by postal track consignment method.
Lordship.
We are rejecting it judicially. Because contempt will lead to punishment of jail of a person.
That's it.
That cannot be on a presumption of service by following this rule. There has to be actual service. That is why. Okay, petitioner to take fresh steps by registered post on the contenders. Same order. Hey, here it logo handi bosun. Oh, it can be.
45.
This consignment track note or something, it's only a presumption.
Yes.
How can you draw up contempt and send a man to jail on a presumption of service of notice? You can't do it. Yes, next item. 44.
44 হয়ে গেল, 45
45.
Lordship notice.
Which order is violated?
9/12/2000.
Page number
Page number 13, operative portion.
30. Is it being served? Have you served it on the containers?
Yes, my lord. Reminder is there, annexure 3, page 22.
Page
22.
third MS issue notice 6 weeks. Please suppose 3 days.
46.
Assigned contempt, my lord, page 9, operative part.
Page 9.
6. Paragraph 6. And acceptance, page 13.
Say, and Sharma.
47.
Yeah, your lordship. Lordship, is this criminal matter also disposed of by your lordship, I may be allowed to. I'll take a signature.
Give it to Mr. Kaushik. If he agrees, we'll pass the order.
My lord.
Third, Mr. A.M.S. Mojumdar, land counsel for the petitioner, Mr. B. Kaushik for the elementary education department, M.S. D.D. Borman, where is she? 9. Government no one is there for the state authorities. The petitioner claims that the issue raised in this petition would be covered by the order dated 28/8/20.
Sorry, my lord. Lordship, by this petition, lordship, petitioners are allowed to produce their appointment letter before the tribunal.
Under a similar situation, my lord, this honorable court has
Only
allowed-
the tribunal case number was different.
No, you are covered by this order. You use the word covered to start. your
covered,
argument.
probably the correct.
Only the tribunal case number is different. Everything is same.
Yeah, that's what we are trying to do. You are covered by this order. Is covered by the order dated 28/8/2023 in WPC 1966/2023. The order dated so and so is extracted as below. The writ petition also stands disposed on the same terms as provided in the order dated 28/2023, and the petitioner would be binding. The petitioner respondent would be bound by the requirements and directions contained therein.
Only one thing is that here, lordship, they are allowed to appear on the tribunal on 15/9.
But however, the date of appearance before the tribunal is now 15/12.
48.
Mr. Bush.
May it please your honor. My lord, that ancestry matter.
What happened?
My lord, my learned friend got the instruction, my lord, they will, learned friend.
Wait.
Bora, my lord.
Which of the two learned friends got instructed?
Mrs. Bora, my lord.
Yes.
My lord, we have conducted the inquiry.
Uh.
Inquiry report submitted, my lord. Two reports submitted, my lord. Main issue is that, my lord, main finding is that, my lord, there is.
Sorry, louder.
Findings of the, my lord, CID is that, my lord, there is a no chance of the CPSC to in the question paper. Because, my lord.
No, sorry, I have not understood what you're saying. Please repeat once again.
My lord, there is a no chance of CBSC.
No chance of CBSC.
To turn the question paper, answer scheme.
Whose finding is that?
My lord. CID, my lord. CID, my lord.
CID.
CID, Inspector, my lord.
Okay, we ordered the CID.
They have made a note, my lord, on that, how they conducted the inquiry, my lord. They said that, my lord, initially, my lord, during the examination, that's from that.
So this will go against Madam Bora or against Mr. Bushra?
Against person.
Give him a copy of the report.
Ma- ma-
Let us see what he has to submit on that.
my-
Mr. P. Saikal and Council.
My lord, one thing, man. My lieutenant Mrs. Bora has informed me that they have agreed to allow me to appear in the exam.
Yeah, do it.
So we are, with that observation, the case may be.
Means we need not go into all these questions. Yes. It will be a happy ending for everyone.
Fine.
As per bylaws, the time is already over. The online submission of forms, that period is over. On the synthetic ground. also,
Understand?
that's-
We'll allow him. Yeah, do it. We are not observing anything.
Always
Ah.
That's right. So Lordship.
It is, Mr.
Allow her to change the exam.
Without going to the, without going to the merits of the, just,
One thing is there, Lordship, if the student has done something wrong, that I would say. Now CBSE has actually.
Papers were conducted on 4 different days. On each day, her paper was drawn.
And this one invigilator, the head.
no, we have said without going to the merits.
And that's why.
Without going into the merits of the claim rate in this writ petition as to who had torn the answer scripts of the petitioner. In a situation where we have also a report by the CID submitted as per the order dated 11/9/2023 that there is a very less possibility of any authority under the CBSE to have torn the answer scripts. We take note of the submission of the Learned Counsel for the parties that on a sympathetic reason, the CBSE has agreed to allow the petitioner to reappear in the examination concerned,
Therefore, like.
which will be held,
2024 exam.
which will be held in the year 2024. The petitioner also agrees to the said proposition. Full stop. Accordingly, writ petition stands closed by providing that as agreed between the parties, the petitioner may reappear in the examination to be held in the year 2024, and the CBSE authorities may allow the petitioner to do so.
Allow the petitioner by online ability.
No, they actually they have to buy online.
In doing so, the petitioner shall comply with all the procedural requirements of appearing in the state examination.
But they're not.
If they want online, if they want physical.
By
If they say your earlier application will do, that will do.
They have to submit. it.
Sorry, MS, your for word. For the authorities under the Jawahar Navodaya Vidyalaya Samiti, as well as Kendriya Vidyalaya Sangathan.
Nine.
Yes.
May I please allow you. I have filed the interlocutory application for striking down the name of respondent number 9 and 10, my lord.
From the area of respondents.
My lord.
Heard Mr. M.A.I. Hussain, Learned Counsel for the applicant. Also heard Mr. B. Chaudhary for SSA, Mr. B. Deori for. You are waiting for somebody. SSA means, I think, Education Department, Mr. Huh? No, for the regular education, you are not required.
Yes.
Mr. B. Kaushik for the Education Department and Mr. B. This application is made for allowing the petitioner to delete the array of respondents number 9 and 10.
My lord.
9 and 10 in WBC 6265/2023. Upon hearing the parties, the prayer made in the application is allowed. the area of response 9 and 10 are struck off. Registry to incorporate necessary correction in the writ petition as well as in the CS system by doing the needful.
But in the writ petition manner, there is an interim that is still to be, that may be extended. Also, I pray for some.
Main petition here, Mr. B. Chaudhary for the SSA prays for 4 weeks time to file affidavit. And on the other hand, Mr. M.A.I. Hussain prays for the interim order to be continued, interim order continued. Affidavit be filed within 4 weeks, list after 4 weeks.
Highly obliged.
50 for hearing.
You want to say?
Time being.
What is this matter, Mr. Kotoki? Part hurt.
Regarding the payment of pension. Man.
Oh, that man, he worked in many different places. Yes, what do you say?
Lordship, the
You want to give him something or nothing?
Your Lordship, the government has taken a step.
We asked the chief secretary to take a decision
Yes.
because it was
Yes.
something interdepartmental,
On the
number of
basis
departments.
Yes, on the basis of that order, Your Lordship, Chief Secretary constituted a high-level committee. Your Lordship.
High level.
Yes, Your Lordship, all the senior officers of all the relevant departments, finance, line department, everything. The 7 members committee was constituted to examine the matter. They examined and submitted a report, prepared a report. On the basis of their report, the chief secretary filed an affidavit. Your Lordship.
Ultimately, yes or no?
No,
No. Why? What is the reason?
Your Lordship, he was not holding any substantive post in the government.
Mhm. There is a Supreme Court judgment.
Yes.
Substantive, unsubstantive, ad hoc. If you have completed the complete career, pension.
Your Lordship, he is
Across the board, if an employee is allowed to serve the government for a complete career, whether he is ad hoc or temporary or contractual or this, or doesn't matter,
Your Lordship,
he will be entitled to pension.
Yeah,
How do you explain that situation?
here the issue is that he was working in the DRDA.
We don't accept that.
The DRDA is the registered society.
Then we'll
They are
ask
non-pensionable.
Mr. Kaur, then
Before that, for few years,
Mr. Kaur, then our answer will be some government official in a misleading manner had required him to work in DRDA, knowing well that it is a society and he will get no pension. So for the conduct, that particular conduct of the government official, you have to adequately compensate this man and give him a substantial amount so that he can keep it in a fixed deposit and earn some money, monthly money.
Your Lordship, the
Government cannot escape so easily, Mr. Kumar.
Your Lordship, the
Madam Das says no. Yesterday we have put her in a difficult question in another matter.
Your Lordship, he was working in the Deputy Commissioner.
Mr. Kumar, the
As a
law,
casual worker. And
Mr. Kumar,
Yes, sir.
the law is by taking all these kind of pleas, a man may not be entitled to be regularized or to be regularly appointed. If that is the answer, if that is the situation, answer is don't employ these kind of people in the manner you are employing. But once having employed, these pleas are not available to you, that he may not be entitled to regularization, but he is entitled to remuneration for the period he worked. And now the Supreme Court had added to it that if a man has worked for the entire career in whatever status, that man will be entitled to pension. This plea that this is there, that is not there, is not available. Now you please submit within the 4 corners of the judgment of the Supreme Court and the actual law.
Your Lordship,
Don't tell us all these things we are already aware of.
Your Lordship, he was working in the Deputy Commissioner, amalgamated Deputy Commissioner staff.
Then we are going to, cost will be even heavier, because why was this man sent to DRDO then?
Your Lordship, he was not a regular employee. He was a casual employee.
Doesn't matter.
Frequent retrenchment was there, Your Lordship. In different works.
Mr. Kumar, if there was frequent retrenchment, this man ought not to have been even allowed to enter the door of the government. He should have been sent away at that stage itself. Having,
Sir, my submission is that he was not in a continuous service
doesn't matter.
and subsequently he
Doesn't matter.
he was
Then
appointed in the DRD.
more and more you are taking these kind of pleas. You are inviting some more and more stringent orders against you.
So Lordship, the government has taken a stand now. I
This
cannot take it.
government stand is not binding on the court. It's
Yes.
binding on the government, not on the court. We will examine whether
That is,
that has the sanction of the law or not. That's
since he was appointed in the DRDA, the DRDA is a non-consensual establishment.
that is, we have heard you on that plea on a number of occasions. We are not very satisfied. The DRDO plea is not satisfied anymore. DRDO is a society, nothing doing, we don't know anything.
Your Lordship,
And mind you, very recently, Supreme Court has even provided that earlier concept of instrumentality of state under Article 12. That is applicable only when it is a petition under Article 32 before the Constitution. If it is a petition under Article 226, all that is whether it is a authority under the law or not. DRDO is an authority under the law, and moment they are authority under the law, they are amenable to the writ jurisdiction, number one.
yes, sir.
Number two, as an authority of law, there is no sanction to the DRDA to violate any of the provisions.
Your Lordship, the DRDA may come under the Article 12.
Not article, other authority,
Other.
within the meaning of Article 226. So very recently it came on judgment. Please go through it.
I will study.
You go through it. So everybody is under the writ jurisdiction.
Yeah.
It's a continuous matter. A man worked for almost how many years? 40 years.
Yes, my lord, from 1982, my.
82 to 2022. Now it's some 40 years.
But the problem is that he was working in a non-consumable establishment.
Mr. Kumar. Can you tell the football to be not a part of the football match? Why everybody is kicking around that football from one end of the other to the ground?
I'm not.
You are simply made this man, given you the status of a football in a football game. And now you are taking the plea that he is a football, so he's not entitled to anything. How can we accept it? Just kicked him around from one department to the other for 40 years. Mind you.
Yeah,
And state is supposed to be a model employer.
Definitely, Your Lordship, but we are also binding by the law, Your Lordship. Is it?
Law also includes that you are a model employer. Law also includes that you don't exploit your people. Law also includes, there is Article 23 of fundamental right under the Constitution.
I don't think
Your
that this is
few
exploitation, Your Lordship.
few regulations framed for your own benefit are not the only law in this country.
Your Lordship,
So we are asking you also, we are not going beyond the law. We are asking you within the law. Your few set of regulations here and there are not the only law.
Your Lordship, the DRDA was.
Okay, fine, we'll put away compensation of 50 lakhs for the entire conduct. Don't pay any pension, nothing.
Your Lordship, the
Yes, that's why I told you. You are inviting yourself for a more stringent order. It's better you do something.
Your Lordship, then Your Lordship, I will study the judgment, Your Lordship.
You go and challenge our order. We are going to order a cost of 50 lakhs for exploiting one employee for 40 years.
Your Lordship, before coming into the DRDA, Your Lordship, he was not. holding
We are not
any
interested
employee. We are not
DRD
an employee.
or any other.
Employee also, he was a casual employee. He was subsequently was appointed, Your Lordship, in the DRDA.
Mr.
He never objected it, never challenged it, Your Lordship.
No,
He accepted it. Your
that will
Lordship.
also not give you any
And
right.
after so many years, now he cannot say that he's a government employee. He should be given
Mr.
the
Kumar, I think we have heard you enough. Should you dictate the order or something other than that? Other than your reputation, do you have something more? Or we go by our order?
Your Lordship, your Lordship has referred to judgment.
Please give human treatment to human beings. Keep that in mind. You are a mighty state. Should not exploit people. Look above the technicalities. Be a little more broad-minded. Everything is not technicality in law.
Lordship, I have all
You are
sympathy
still
for
arguing.
this. I have all sympathy as the
Then
personal
do,
level, I have all sympathy.
then execute
But
your
still
sympathy.
has taken a step, now I cannot take it. But
well,
whatever
that-
maybe your Lordship, it is not binding upon your Lordship. So your
Definitely,
Lordship,
then
I'll
we will
examine-
definitely take it.
I'll go to
But
the
mind you, tell your chief secretary the decision may be a little more harsh. So it's, if you want a lighter one, it's better come from your side.
Yes.
If you go strictly by the law, it may be a little more harsh on you. There may be some observations also which may be a little damaging. You should not. In Assamese, they have napai koribo. Certain things are there also. Everything is not a technicality of law in this world, Mr. Kumar. And everything is not a few set of regulations the government frames for their own benefit. There's something much beyond. So if you compel us to write a judgment, we are ready to write it. But that may be little more damaging for you.
Should be
Think a little, brother, Mr. Kaur. Think yourself in his place. Would you have liked it? Ask the chief secretary to be in his place. Would he have liked it? He had a very nice career. Day one, the way he entered the service and he will go out. Do you realize what these kind of people they face? When you always had the opportunity that from tomorrow, please don't come, because we can never accommodate you in the manner it is. And had you said so, and you would have filed a writ petition, maybe you would have dismissed this petition. Then you would have examined what right he has under the regulations you are referring now, what he does not have. But exploiting for 40 years thereafter, I don't know whether you are in the same position or not. From 82, had you had done this in 1992, we'd have been with you. With all your arguments you are raising today.
We are not disputing since 1982, he was continuously working here. But under a not
Very
pensionable
good. We are aware of the facts, it's already judicially noted. You don't have to repeat it. Very well, so we are not doing anything. Then we'll do it. We'll do it. And we may put a few strictures on your officers also. Take action against them. Take action against them.
If someone is responsible, we will have to take action.
Not have to, you are bound to. And whatever amount we say, you extract it from them and compensate the state exchequer.
On the other hand,
We expected the chief secretary to at least look into this aspect and never expect the chief secretary that he'll also go only by technicality of law. That's why it was referred to the chief secretary, thinking that he's a little higher than others.
Yes.
Ask him to reconsider it.
I'll have to.
Give something token, be fair, we'll close the matter. And we'll also provide that he not be a president also. Get that protection. But if you rely on technicality, we'll also judge as per technicality of law and within the complete four corners of law, and not just a few set of regulations. Didn't you feel bad for this man?
Yes.
Other than very humble way saying yes, have you felt anything more than that? See, if your son will be in that place tomorrow, will you like it at the end of his career?
Unfortunately.
Will the chief secretary like it? Hmm. I know this is the maybe most unwanted man. Why did you exploit him for 40 years then? If you know, I think your way you are relying on regulations and law now, you are uttering the law repeatedly under the law. If your authorities know the law so much, why did you allow him to be exploited? You should have invoked the law a long time back.
One thing more, Your Lordship, I would like to add, Your Lordship. Your Lordship,
We are not passing order today.
Rule, Rule 31 of the.
Every rule is made to regulate the conditions of service. None of the rules are made to exploit the employees, mind you. We are giving you some time to introspect and come up with a more clearer mind. Yeah, the Chief Secretary also. Mr. Kumar. Refusing is the easiest of things. Giving is more difficult.
Yes.
If from the morning I would have said with a determined mind that I dismissed every writ petition, it was the easiest thing for me to do. There is bound to be a lacuna here or there, small something. Latch on to one word, dismissed. My work is over. What? Yes, I have finished 60 matters in a day. Very satisfied. Difficulty is giving. Here you have to apply some more mind.
Dispose of the matter,
In what time?
Rule 31 may read your.
What 31? 31 of what? 31 of what you were trying to read?
Pension rules, Your Lordship.
Pension rules. Supreme Court has already taken care of that pension rules. In one paragraph, Supreme Court has decided that if you take the services of a man for the entire career, you should pay pension. No matter in what manner he was appointed or he served, or where he served, or where he was treated like a football, like in this case. 2 years here, 3 years there for 40 years. Introspect, that's why I'm telling you. Let's get a video next week also. Feel for these people also. If you say you're not getting anything, but I'm giving you some compensatory benefit, maybe we'll accept that also. But not that you are not entitled to anything. Just. And mind you, the Chief Secretary was directed, all the circumstances were stated in an order when he issued direction. He did not make an inquiry and restate those circumstances. It existed. We all know it existed. We only asked him to know over and above this, what can be done. Possibly he did not even look into that one.
He constituted a 7-member committee.
Doesn't make strength of the committee will not make it more acceptable. He possibly may not have even looked at it, the real purpose of our order. Next week, come back, but not with the same answers. Don't repeat. And if you have to repeat, tell us that I have nothing to say anymore. But if you can think of something, yes, think about it. And the worst of the violation you had done is that knowingly, why did you send him to DRDO then? That day, had you sent him off, I would have been with you. And another form I have signed, somebody dies, a man makes an application for compassionate appointment. She'll be allowed to work in the post of that deceased person, but don't pay him anything. Yes, we are doing it, we are doing it. And after 15, 20 years have gone by, oh, nothing doing. You were appointed by the managing committee, which is against the rules. Okay. But trying to show that we are giving you, doing everything, in fact, you are taking away everything from that person. Better you, why don't you have the guts to reject it at the very outset? You are not entitled to anything. Please don't come. But that should not be after 40 years or 30 years. Difficult. I think you can use your good office. You're the additional advocate general. You can use your good office. See what can be done. Discussion. Just explain.
One.
Technically, to law, we are with you. You are right. But beyond the technicality, you see what can be done. Mr. Kotogi, you also don't expect that you will get everything. But please give something. Take a decision, give something.
Maybe. I pray for 2 weeks time, my lord, for producing the record.
2 weeks time on the prayer, Mr. B. Kosi, about the education department.
But I am not getting anything, my lord, after 7 years of my retirement. Neither my lord provisional nor GPS.
Some key matter.
2009, my lord, he submitted an application for VRS. And that application was rejected. Since 2009 February, he left coming to the school.
Actually, you didn't, you were not in service.
No. After my retirement, my lord, my BRS has been rejected. After 7 years of my application.
No. After?
7 years of my application, they, my lord.
Where is the provision that there is a presumption of there being VRS? Who has prevented you from going?
Yes. If submitted an application.
You voluntarily you abandoned your work.
No, my proposal.
Mr. Ali, suppose one employee today gives a VRS application. VRS application can be dealt with only by a positive order. Yes, we are accepting your VRS. Until the positive order is there, it is deemed that they have not accepted it till then. Meaning thereby, you are continuing to be an employee who is required to go to attend your work.
Now here, my lord.
If you don't do it, law will understand you have abandoned your work.
Now here, my application was forwarded from IS to director to government. Government is.
Doesn't matter. You should have come in a writ petition, direction that please pass an order in my VRS.
And after retirement, they passed the order. After my normal retirement date.
Yes, they have taken the maximum advantage of your misconduct.
So, my lord, otherwise he is, my lord, entitled for pension. That was also not possible.
How much pension?
Nothing, my lord.
No, how much pension you
He
are?
has completed 20 years, my lord.
As on which date?
On the date of submission of.
Date of submission of VRS, he had completed 20 years.
And 19 years, some months, my lord, and crossed the age, my lord. 50 years has already been crossed.
Maybe.
Lord. So otherwise.
See, if they are not accepting a VRS, the remedy for you is to come to the court. That take a decision on my VRS. But that remedy is not to sit tight at home, that I'll do nothing from today. This is the first aspect. And on the day you stopped your work, did you complete the qualifying period for pension?
No. But through provision, my lord.
No provision. Did you complete? Did
No,
you?
19 completed.
19 years. What is the law?
Well, 10 years, my lord. Provision.
Sorry.
10 years of service, my lord, for pension, my lord, qualifying service.
10 years, not 20 years.
Oh, my lord.
Yes, yes,
10 years,
Mr. Kaushik, is that the law?
My lord.
Qualifying period is how long?
Qualifying, my lord, 10 years. my lord.
I think it is 10 years. After 20, you get the complete pension.
Complete
Before some proportionately,
Yes,
you'll get a lesser pension. But that doesn't mean he'll not get no pension.
But-
Number one.
Yes.
Number two, he remained absent. That's a misconduct. When did he retire?
He retired on
29/2/16.
February.
16. So you could have proceeded in a departmental proceeding against him within 4 years of 2016. After 2020, you cannot. You should consider his pension for the service he had already rendered. Because he is a man who retired from service.
Technically,
There
yes,
was neither a suspension, there
neither a
was
suspension
nor a
nor a
proceeding, nor a termination.
not at all. What has happened, my lord? He went to participate in the MP election, parliamentary election, and he has submitted an application
So,
saying, give my,
Mr. Kaushik, that's a misconduct.
yes,
You could have
Apparent-
proceeded against him,
apparent-
but you did not do it.
some
What you have not done will not help you now.
so-called notice was issued to him. But I don't know what has happened to the.
Nothing.
Doctor will give us some time, my lord. We have already requisitioned the record.
List next week. On the issue as to why the petitioner should not be held to be entitled for pension for the period of service he had already rendered to the department, which is stated to be about 19 years, some
19.
months, but less than 20 years. What did he say? He was whatever.
I'll also have to get it from South Salman. I'll have to also have to get it from South Salman.
What? South Salman? No, we want you to submit on the law.
Well,
South Salman will not help you in law.
records also, my lord. The
Record not required. It's a admitted position. He served for 19 years. Don't need the records for that.
whether any proceeding was.
Only, that you get it telephonically now also.
Item 53 for motion.
He who is appearing. What is this repetition? Provincialize the service. Recommend the name of petitioner. Interim of the respondent number 6 shall be stated. Why?
He's junior to me. This is an ME school, and both of us, petitioner and respondent number 6 are language teacher. I am much more senior to.
Yes, Mr. Phukan, what do you say?
My date of appointment is.
Heard Mr. B. asked and council petitioner also heard Mr. A. Phukan for the elementary education department. The petitioner, notice 666, the petitioner Prafullo Kolita and the respondent number 6 Surya Borthakur are both teachers in the Honaram Horma Balya Vidyapith in the Jorhat district. Petitioner claims that, and both of them claim to be language teachers in the school. But when the process for provincialization was undertaken as per the Act of 2017, the respondent 6 was provincialized, although in terms of service, he is junior to the petitioner and both of them are language teacher. As the law provides for provincialization of only one language teacher, it has to be understood that the senior between the two may have a better claim for provincialization in view of the prima facie case made out. Further benefits of provincialization be not given to the respondent number 6 until further orders.
54 for admission.
is this matter? That income tax matter. Did you get anything?
I find very interesting this point because the challenge of the petitioner.
You want to make some further submission?
Yes. I prepared a note of them.
Uh,
Because there was a judgment of Calcutta High Court.
Kerala High Court.
Calcutta High Court. 161, whether notice after seizure, notice can be issued under section 181(1). Then Calcutta High Court said no, you cannot issue any notice after seizure, certain seizure. Then amendment was made. And although the matter didn't reach to the Supreme Court, the different High Court.
The amendment was made and 1A was brought in.
Then it was different High Court gave in favor of the department that it can be issued after certain seizure. But Allahabad High Court in 2004 held that no, you cannot.
No, it is under 131(1) or 131(1)(a). What is the reasoning behind such conclusion? No. What is the reasoning? The relevant paragraph?
To overcome this difficulty, section 131(a) was introduced to extend similar powers to then extend director of inspector. In 1976, section 131(a) read as, if the assistant director of the inspector reasons to suspect that one income has been conceived or is likely to be conceived by any person or class of person within his.
Did any of the high courts go into the expression before?
Yes, sir.
How did that is answered?
One judgment yesterday.
That I got, the Jharkhand.
Then Allahabad High Court also got one book. Say that here all the judgment against and in favor of the department has been delivered. He made research, then what
Achha, somebody made a research.
Yeah, that is good. And chapter 48 is dedicated to section 130.
Mr. Kyal, this is where we are having a little difficulty in understanding. Even in this book, you'll notice one aspect that that none of the courts had gone into this expression before he takes under action. None of the high courts, while dealing with 131(1)(a), had dealt with the expression before he takes action under clauses so and so, so and so. So that is, when this is a statutory provision, even law of interpretation of a taxing statute says that express words in a statute cannot be ignored or given a different meaning if the meaning is clear and explicit. Here it is clear, it says this power will be invoked before he takes action. So before he takes action under 132, he can do anything. We are not trying to restrict that. But once having exercised under 132, how can we give a meaning to this expression before he takes action? This is where we got stuck yesterday also. And even this, Mr. Sharma, with all due respect, see, when they compare 131 and 131(1)(a), here in 131 he writes, whereas 131(1)(a) can be exercised notwithstanding no proceeding is pending before investigation. In other, 1A can also be for the purpose of a preliminary inquiry. He is right.
Yes.
But while considering the difference in aspect, no one had given attention before he takes action, this provision. And Jharkhand had given the one, but the meaning given by Jharkhand is very difficult to accept. The reason given is very difficult to accept. It's almost
basically Jharkhand High Court relied on the judgment of Gujarat High Court.
I know, but nothing is stated. If a high court takes a view and gives a good reason for that, we have no difficulty in
No,
accepting
no,
it.
that is.
That's why it's called persuasive value.
Yes.
And persuasion is not by the view, by the
reason.
reasons. If the reasons are absent, what kind of persuasion can be there?
That's it.
You need some more time.
On Wednesday.
Because once we have framed the question, we are bound to answer it now.
Yes, sir. And Lord, I prepared a note. Although it is 11 pages,
Doesn't matter.
probably it will be very helpful for your Lordship to. Lordship in Jharkhand High Court, in page 21, reading 59.
But we have to take note of certain principles of interpretation, that no words in a statute are excess. No words can be given no meaning to it, as if it does not exist.
No, that is Lordship Dilip Kumar
And number of, that's a general principle.
Court says that
So how do we give a meaning to before he takes action, this expression? Meaning is very clear, that before he takes action under 132, he can invoke this power. But once 132 has already been invoked,
130, that's why Lordship.
the requirement of before he takes action is already over. That is after he takes action.
That's why under section 131.
And even General Clauses Act doesn't say that word before can be read as after.
No, Lordship, this is the peculiarity by introducing this provision.
Somebody missed out somewhere.
And
You can amend this provision and reframe it.
no, it was amended on after the judgment pronounced by the Calcutta High Court.
Mr. Kyal, I understand that. Maybe the intention and purpose was that.
But language.
But and this expression, if you delete it also, then what you are trying to say will fit into place. But why did you use these extra words?
What have you understand?
You have created your own problem.
What I gathered from the officers when I studied talking, they given me this note also. They said that when the Calcutta High Court passed in judgment, that after certain seizure, 131(1) cannot be invoked. And so
If Calcutta High Court goes wrong somewhere else, to overcome that wrong, you reframe the statute, amend the statute. But we have to give meaning to the amended statute,
yes, sir.
not the purpose why it was amended, and give it a different meaning. We can't, it will be wrong. And this happens, now this is an issue before this court.
Yes,
Had it not been an issue, we would have ignored it.
So this is the main issue. Their contention is that after sunset.
So you again amend 131(1) and delete those words.
Let's confirm your Lordship.
Send it to the parliament that these words should be deleted. Gone. Your purpose is served.
If some.
And number one, and even this Calcutta High Court, we are not fully agreeing with it. As I told you, under 131(1)(b, although Dr. Saraf was not agreeing with it, there was a small window to reopen it.
Probably.
Possibly Calcutta High Court were wrong in there also. So 2 wrongs, 3 wrongs had resulted you in this situation.
Possibly quicker to 132. If they were committed.
You ride your luck. As long as I am here, I will decide it. If the time passes, thank you. I think it's a.
I find very interesting yesterday when I go through this. I'll come up with note and on coming from that I'll submit a copy to Mr.
But that's a very explicit provision and very clear before he takes action.
Not that.
So the power can be invoked only before he takes the action. Now I cannot give it a meaning that will also include after he takes the action.
If I may be wrong, but what I have understood that while conducting certain seizure, when the officer thinks that some information has been posted by the SSC, then they can invoke this provision for further inquiry.
That is, you are assuming you can invoke it. But a provision itself debars you from doing it. What can I do?
The
The presumption or assumption of the departmental officials will not give a different meaning to a statutory provision.
Definitely not.
Mm.
But taking help of the has been decided by different high court. And submitting.
See, different high courts must have brushed aside this issue.
But in one of the paragraph on Wednesday, I will contact you. That is very clear. That
You produce one judgment where a different meaning had been given to this expression
Yes.
after taking note of it, and the reasoning given is persuasive.
Yes. And
We'll be with you.
Yes.
But anything short of that will be
No,
little
no, sir,
difficult.
definitely. I'll also not hesitate with this. Much.
Item 55.
Or you can, following our judgment, you can go for a further amendment. You go for it.
If that is not, that can be.
The taxing laws are amended very frequently. Whenever something is pointed out by any of the courts,
Whenever we find.
sometimes what happens, presumptions keep on going, as if it is like this. Whenever some court points out something, the remedy is to immediately make an amendment.
If I find out one judgment, that not so. He said that while dealing with the tax matter, the normal procedure will not be applicable in this case because this is a.
I am telling you by going for the principles of interpretation of a taxing statute.
I'll place that.
Taxing statute a little different, but even taking note of the difference, this one will be difficult.
I'll confine my argument to that.
But the interim order may be directed to continue.
He won't do anything, don't worry.
No, nothing. And lots of in the meantime, final assessment has been completed. I also informed Mr. Saraf. He told me that since the law point is there, that the court decided that
Let this law be decided, and other one you do whatever you do.
already it's completed.
You do it.
And they are also not aggrieved by the certain season. Their contention is that notice under 131 typically.
That notice will go. After that notice will go.
And then lots of Allahabad High Court says that even if the lottery falls that the notice under 131 was there, but
They can always issue a re-notice.
no, that surgeon will be there. Only the subsequent decision of the department.
No, that is in a different context. When the notice precedes the search and seizure. But here is a search and seizure preceded the notice. So if the notice is bad, search and seizure itself may not be bad also.
Yes,
That is.
This in this contract application, my lord, the speaking order has been passed by the secretary, my lord. In my opinion, my lord, he has a wrong understanding of the judgment.
It's stated by Mr. B. Kochi, Land Counsel for the respondents in the School Education Department, that although an order in compliance had been passed by the director,
The secretary.
by the secretary of the department, in compliance of the order which is alleged to have been violated, but the said order is incorrect to some extent, and therefore the secretary intends to recall the order and pass a fresh order.
Right.
Adjourn for 2 weeks. For the
Order
2 weeks
dated-
or how much?
Order dated
4 weeks time.
Order dated 11/4/2020.
Photo to writer lage nahi. Oh, timing এটা কি করবা গোল?
Well, can be 4 weeks time.
Timing এর পিছত মিস করাই দিও বা। No, time being word is time being. So there has to be time. When there is no time, there is no time being. It will be deemed to be adjourned to be listed again.